give a fuck what you say. Yeah, I'ma do shit my way. So you can go kick rocks, I'ma stack bricks up, build what I want to make.
Yo, I got a lot of shit to say, so I'ma do this every day. I'll be writing things until I'm fucking buried in my grave.
We would be granted a new trial. So that means we're going to have to do this all over again.
Oof.
In
wanna do that, Judge.
amusement sales versus state 316 Georgia Appellate 727. That's a case that cites Whitworth, which is physical precedent only. The court said, if the assigned prosecutor has acquired a personal interest or stake in the conviction, the trial court abuses its discretion in denying a motion to disqualify, him, and the defendant is entitled to a new trial, even without a showing of prejudice. So that means if we show the court today, and I think we have through the proceedings today and before, that Ms. Willis has developed a very personal interest in this case, and Your Honor denies this motion, we're coming back over again. If the appellate court say you were wrong.
So what is that personal interest?
So the personal interest can be what there's no definition of that under Georgia law, and it could be a personal financial interest. It could be a personal interest related to bias against a particular defendant, which sort of falls into the forensic misconduct
with her
box.
boyfriend.
But we have here a very personal financial interest that's been laid out in terms of money received by Ms. Willis as a result of the scheme that she set up.
And more than that.
And
nice. And more than that.
To get to the issue of the personal interest in the context of an appearance, I think that's important. I do want to suggest to the court that there are a number of cases that post-date this actual conflict of interest language that's suggested in some of the cases from the 90s that you have to pay attention to what this looks like to the public. And I agree with all of the law, and I'm sure the state's going to stand up here and say it can't be a speculative or a conjectural type of personal interest. We don't have that. We have something very concrete.
Go to the home office today, though.
As Judge McBride said,
Been working all morning.
actual and palpable, not
I'm waiting
speculative.
for this to come on.
Exactly what we have here. We've demonstrated through the testimony of the witnesses, some of whom impeached themselves, that we have a very personal interest. In the seminal United States court case that deals with prosecutorial impropriety is Young v. U.S. That's a 481 U.S. 787 case. In that case, it's the opportunity for conflicts to arise that created at least the appearance of impropriety. And that's the case that requires that the prosecutor be disinterested. Since a scheme injecting a personal interest, financial or otherwise, into the enforcement process may bring irrelevant and impermissible factors into the prosecution.
Keith Anderson.
Now, there are a number of Georgia cases that sort of repeat that theme. Reeves v. State, 231, Georgia Appellate 22, that's 1998 case.
Judge is looking at his list.
Potential conflict of interest existed and the appearance of impropriety existed. Davenport v. State, 157, Georgia Appellate 704, that's 1981 case. That was decided 7 years before Williams. When there is at least the appearance of impropriety, a defendant is denied fundamental fairness in the state's prosecution of the charges against him or her. There are also rules that govern prosecutors. Lawyers in general are bound to preserve and avoid even the appearance of impropriety.
That's true.
That's Brown v. State, 256, Georgia Appellate 603, 202, 2002. Head v. State. A prosecutor's close personal relationship with the victim in a case may create at least the appearance of a prosecution unfairly based on private interest rather than one properly based on vindication.
I think the judge is looking at his case list. He's done his
Yeah,
own research.
ABA criminal justice standards for the prosecution function standard 3.3-1.2C. A prosecutor should avoid appearance of impropriety in performing the prosecution function. 3-1.7F. The prosecutor should not permit the prosecutor's professional judgment or obligations to be affected by the prosecutor's personal, political, financial, professional, business, property, or other interests or relationships. So the rules that govern her in her own profession say that this is wrong because she developed a financial interest in this case. And at the very least, created the appearance of unfairness towards these defendants by setting up a relationship, a prosecutorial relationship with her boyfriend that she'd been dating for 2 years, according to the testimony. So before I move, Your Honor, to the specific, you asked, what's personal interest, and I think, frankly, as I was trying to figure this out, I think you know it when you see it. It's just like in the concurrence in Jacobellis versus State of Ohio Supreme Court case from 1964, Justice Stewart, in his concurrent opinion, said, "I know it when I see it." Talking about obscenity, I think you know it when you see it. I think there's enough facts in front of you that you know it when you see it.
If he dismisses
so I
the
think
prosecution,
that governing
he doesn't get
principle
paid.
helps enlighten
That's the connection.
some of the facts here. And also, I think it's not just financial. In McLaughlin v. State, I think the court's very familiar with that case, 295 Georgia 609, 2014. The Supreme Court essentially
Oppenheimer?
said
Yeah,
that
it's a very
because
good movie.
the acting DA had become a witness in the case.
It tells you how
and
evil our
developed a
government
personal,
is.
interest in the
After
case
using
due
him
to
to
his
do all
daughter's
that, to build that,
with the
they
victim,
tried throwing him under the
that he was
bus.
disqualified. And because he was disqualified, his entire office was disqualified. So turning to the facts of the case, Your Honor, I think I've got, my role is 20 minutes, so I've got about 8 minutes left. So why the relationship, why did we spend so much time on a relationship between these two people?
Perfect
We
actor for him,
couldn't
though.
care less if
I
they
really
had a
like that
personal
actor.
relationship outside of
Can't
work.
think of his name,
That
but
is
yeah.
not what the issue is here. The issue is that they began this
Loved him in
relationship
Peaky
in
Blinders.
2019. They were dating for 2
And we need
years,
Bob's.
and then she awarded him a contract
And then reawarded it.
where public money, either from Fulton County or the state of Georgia, ended up in his pockets.
To her boyfriend.
That decision alone was improper. But what's even more improper is that then she and he used that money to go on personal vacations and trips.
With her. His
If Your
presence
Honor
was a
will
benefit.
remember, exhibits 9, 11, and 12 dealt with the expenditures by Wade on trips. If you do the math on that, if you look at what he spent,
I haven't watched
and
any of the
then
recent
you look at the testimony about what was paid back
Batman movies.
by Willis.
I think
Because
after
the
the third
cash
one, I stopped
reimbursement
watching.
theory, well, I'll talk about in a second, but
Yeah, Joe Cleary.
if you do the math on what he actually paid for it and what they testified she paid back in cash, you still have over $9,200, $9,200 and $9,247 to be exact, is the amount of money they cannot account for in their testimony. And as Your Honor will remember, there was no of cash in Mr. Wade's affidavit when the best and first opportunity to raise that issue would have come up is when the state filed their response in his affidavit. That is nowhere to be found in there.
They
The
just
first
made it
time
up.
we heard about cash was here in this courtroom.
Oh, cash, Nathan said.
And so I think she's received a personal financial benefit of over $9,200 in this case that she can't account for and the state can't account for. And the reason we can't account for it is because they came up with a cash theory. The cash theory only
Before we
raises.
get into that, let me ask you this. Let's say let's say the theory wasn't even there that they had paid it back or that
Any
there'd been any
cash.
exchange. Should there first be a consideration of a materiality requirement?
No.
Have you
there's
seen
none.
that in this jurisdiction or, it's not in this jurisdiction. Have you seen that in any other jurisdiction?
I haven't seen that, Judge. And if it was $6, that would still be improper.
Wow.
Would it
okay.
be improper where it's a per se disqualification if someone, buys their boss a stick of gum? Is that per se disqualifying because there's no materiality requirement?
Well, no, I don't disagree that it may not meet a materiality requirement, but it's a personal benefit. I won't say
Yeah,
that give
it
me a
is.
pack of
Stop it.
gum is just justification for disqualifying a
Sorry.
district attorney. I think that's part of the issue, Judge. I think it's a fact-based brief by you.
So there's a continuum involved here.
Yeah, but I think the continuum involves you looking at whether or not in the grand scheme of things, it violates the Constitution, and whether or not there's an appearance of a conflict, and the appearance suggests that she
Basically
actually
hired her
received a
boyfriend to
benefit.
go after
And we know
Trump.
that she
but
did. They
paid
admitted it.
him
We don't
more
have to
than everybody
speculate about
else.
that. They said that she said she got a benefit, and she said she paid back certain amounts. In that regard, Your Honor, I don't know, would $100 be enough? Would $200 be enough? I think you have to look at it.
Yeah, take the money out of it.
globally and consider all of the witnesses, consider all of the facts, consider the credibility of the witnesses, frankly.
Right.
I mean, Your Honor sat here and watched everybody, so I haven't spent a
Why?
lot of
Yeah.
time going into the specific testimony because Your Honor is well aware of it. But you get to evaluate the credibility of the witnesses as a fact finder. And, you know, just
Just from a legal perspective, though, you're saying we can't just say dollar amount, look no further.
No.
There has to be a totality of the circumstances analysis.
I think it's fact specific, Judge. I don't really want you to pin me down on that because there's no law on it. I can't give you a straight answer because I haven't seen anything like that. And I think if we build a materiality requirement into the case law, then you're down a slippery slope there because then it's going to be very
Very
well, is
subjective.
$50 enough? Is $100 enough? So I think it's not necessarily the amount of the money.
Really?
It's the fact that she
I mean-
received it, and it's not insignificant. And I don't think your order has to
You
say
don't think-
because
you
she
don't think the
received
white tears would,
$9,200, she's
Yeah.
disqualified.
Also be
I
called out.
think if we go
because
back
of
to the
this?
20,000-foot level,
Probably.
what's the appearance here? Is this fairness?
I think
to the
they just thought they
defendants?
were untouchable.
Does it appear that she is interested in this prosecution, or does it appear that she's disinterested? She took the stand. You can tell she's not a disinterested person when it comes to this proceeding, but we also argue she's not a disinterested person when it comes
That's
to the
true.
prosecution as a whole.
A-hole.
So I'd like to take money out of it.
I'm going to leave
She's
for.
still got a benefit.
I'll resist the temptation to defend my wife, and who I believe to be an excellent lawyer.
Heck
and
yeah.
A member of the bar for 20 years.
Shout out to Ashley.
In good standing. But I will say this, Judge,
Good
you
husband.
don't just evaluate the credibility of the witnesses. You evaluate the credibility of the lawyers. And Mr. Abadi stood up here in open court in front of national news
Yep.
and then the national public and called her a liar.
Yeah, he did.
I need to address that for 1 minute.
Thank you.
There's text messages that are now part of the record, which now are substantive evidence for you to consider. Prove
Hey,
everything that she tried to elicit from Mr. Bradley was absolutely 100% true. And not only was it true, she verified through the witness himself that the motion was
that
accurate for
part.
his file. So for the state to get up
2011.
here and impugn her credibility, it's not only improper, it violates Berger versus United States, which is a case that says the state can't just get up here and make any argument it wants. And I encourage the court to call him out on it when he steps up here. We have to have candor towards the tribunal. You
Yep.
cannot lie to the court,
Yep.
cannot lie to the public, cannot lie to the jury. And I think that's what he did.
And Anna did too. They did.
So there's other corroboration of our view that she was in this relationship. I think, frankly, based on Mr. Bradley's testimony, Your Honor can separate the wheat from the chaff when it comes to
That was great.
credibility. But Mr. Bradley had 2 chances to correct information that he suddenly developed amnesia, and he just didn't do it.
How does the timing of the relationship impact a financial interest?
Because it's part of the scheme she created intentionally in order to give benefits to her boyfriend. So there's a reason why they fought so hard on this, Judge. I mean, there's a reason that every single subpoena was objected to. Every time we asked Mr. Bradley was objected to, the jumping up and down, all of the obfuscation. There's a reason for that. They know that if Your Honor finds that relationship started in 2019, that the appointment of Wade itself was improper. And if that was improper, then he had no business as an average citizen, along with the fact that they didn't have approval from Fulton County to appoint him in the first place. That undermines the indictment, creates a structural impairment in the indictment.
Yes.
Because he had no more business being in the grand jury room than I did.
Yes.
So that's what they're worried about. And the reason why it's important for the financial piece, Judge,
That's
is it's how
material.
the money ended up going back to her. She put her.
I know you guys
boyfriend
were
in the
talking about
spot,
this a little bit
paid
last
him,
night
and then
with
reap
other
the
ones, but
benefits
Yep.
from it.
Got trips, got vacays.
That she created the system
Yep.
and then didn't tell anybody about it.
Good stuff.
She didn't even tell her dad about it. So I think if in the grand scheme of things, if you're looking at the totality.
Judge
of
writing
the
that
facts,
down.
And I've got to sit down here in about 2 minutes to make room for my co-counsel. If you look at it, everything put together, judges, they did this, they knew it was wrong, they hid it. And even when they were called out on it, they tried to create an excuse for it by saying it happened after the fact.
Yep.
We know
Cover-up.
now from the testimony, Ms. Yuri
Cover-up's worse
confirmed
than the crime.
that Mr. Bradley, his text messages were accurate. in court testimony, but
Bless you, Judge.
that fact was accurate. The motion is accurate. And so also, I do want to point out, there's no paper trail here for the cash.
Of course not.
I know that this was I know she and her father both testified
Cash.
that they kept cash on hand.
Yeah.
Which, I mean, keeping cash on hand in and of itself is not a problem. When you're a public official and you're required to keep track of gifts that you receive, then you need to keep track of it. But there's no paper trail. There's no deposit history. There's no withdrawal history. There's no receipts.
Yeah.
None of that.
But you're a white guy.
Even assuming their testimony could be credible, and we don't think that it is, you still don't have enough information to track all that money that she
Yeah,
received.
you're just white.
And
You
this
don't
is just what
But
we
does
know
the
about.
lack of evidence fall on the state?
I'm
Isn't
sorry.
does the lack of evidence fall on the state? Isn't that where burdens come in?
Yeah, yes, I think they had an obligation to tell Your Honor, hey, this is where the money went.
Yeah.
And they certainly had the ability to do that if they could do it.
All
Since
right,
they
LB.
didn't do it, we have to assume they
I'm
can't.
drinking coffee myself.
they
I'm trying
can't,
not to fill up another cup.
I just want to remind the court of a very important piece of testimony from Ms. Willis that I think goes to credibility of all of the officers of the court who testified. She met with Wade and they developed in 10 minutes after talking about the financial piece, I believe, this cash theory that could not be rebutted. We have no ability to do that.
Yep.
They did,
And
and they chose not to do it.
And they're lawyers. Okay.
So with that, Your Honor, unless Your Honor has more questions for me, I'm going to sit down and turn the podium over to my distinguished colleague, Mr. Sadow.
Thank
Excellent.
you, Mr. Merchant.
Appreciate the court's time.
Okay, that was really good. Started off a little slow, but my gosh, that was very good. So
All right.
we actually
grab a cup
did
of
get
coffee.
to
I'll be
some
right back.
materiality, right? He was
Say
saying
that
there are
was good,
actual
though. This is
consequences
Trump's
for their
lawyer.
misconduct that are structurally
I kinda wanna see
impairing the
this.
indictment. It has
Yeah,
to
let me
be
hurry up.
also, in addition to be disqualification,
Hey, buddy.
it also has
You
to
got the
be
German Shepherd
dismissal
laying next to me.
Good
because
afternoon, Your Honor.
the whole prosecution's invalid. Steve Sadow,
I'm
Trump's
going to
attorney.
speak to what I would call a subset of forensic misconduct.
Steve,
And I'm going to assume that all the law that's been provided to you in pleadings as well as emails, you don't need me to tell you what the law is. So I want to just set up how the disqualification and then dismissal of the indictment should take place
Let's
under
go.
the subset of forensic misconduct.
let's go. So forensic misconduct.
Roman's counsel, Ms. Merchant, filed on January 8th her pleading, her motion to dismiss and to disqualify. We were in court that Friday of that week in which I made it known that that is President Trump, may adopt that motion. I wanted to see what was going to happen before I did so. That Sunday, which would be January the 14th, 2024, DA Willis took it upon herself to go to a historic Black church in
She did.
Atlanta, having not responded at all to the motion,
Why, God?
Ms. Merchant's client. Roman.
Why?
And she made what we now call the church speech. And Your Honor has reference to that. You didn't necessarily want evidence on that, but you know what the church speech.
They're beating on Nathan
speech
Wade
was.
because he's a racist.
It was
They're all
videoed.
racists.
It was clear that Ms. Willis had notes. She was reading from notes that she had prepared. It was a calculated determination by Ms. Willis to prejudice the defendants and their counsel. How so? By making an issue out of the fact that the person that was challenged in the Roman motion was Black,
Yep.
without telling the public or the church members or anyone for that matter, that the reason that Mr. Wade was being challenged was not because he was Black, had nothing to do with race.
No.
It had to do with the relationship that had been alleged and later admitted to by Ms.
Both of them.
Merchant.
That's the hibbity dibbity.
Ms. Willis took full opportunity to the defendants. And then comes along later in a pleading and says it wasn't designed or intended to be at the defendants at all, or the defense counsel.
Total lie.
Which with all
Obviously.
due respect is just nonsense.
Yeah, totally.
The purpose of that was to get public sympathy, public empathy for what Ms. Merchant had already alleged in her motion.
Yep.
Now, that was a violation of the professional rules of conduct. It was a violation of 3.8 G.
All right.
There's no
Hey,
question
Michael.
about it. It wasn't in response to anything that was said. It
Give me a cup
was
of coffee.
a public statement, extrajudicial, for the purpose of making a comment upon the defendants.
It would be in response to a motion that was filed.
But it wasn't filed in a response, in
In
a
a court,
pleading. It was
yeah.
filed in response to a motion. And the motion were allegations made. If Ms. Willis wanted to respond at that point, she could have said the facts of the matter. Instead, she misstated what the situation was, took advantage of the opportunity, an ethical violation, and the ethical violation makes it clear that you must refrain from making extrajudicial comments that have a substantial likelihood of heightening public condemnation of the accused. Can you think of anything more that would heighten public condemnation of the defendants than alleging that defense counsel and the defendants were making their motion based on race and religion?
In Fulton County, Georgia.
That's as bad as it gets in Fulton County, with
Yeah.
all due respect.
Yeah, not appropriate.
That's exactly what Ms. Willis wanted done.
To cover up
And
her
remember, the state
relationship.
still had not responded.
Yeah. She went out to
So then what we
battle in
get
the
from
court
the
of public
state
opinion.
is we get an affidavit filed as part of their response.
Lies.
And that affidavit says specifically, and the affidavit is Mr. Wade, says specifically in paragraphs 26 and 27 that the relationship did not begin until 2022.
Relationship.
It
Whatever that
acknowledges
means.
the relationship and says it didn't begin until 2022. And the pleading that's filed, the state's pleading in response, indicates not exactly that, but it says there was no relationship as of November 1 of 2021. And that's on page 7. So that timing is the issue, because Ms. Merchant made it clear that we alleged and had evidence that indicated the timing was
John.
before Mr. Wade was hired,
Love you.
not after.
Thanks for dropping
So
in.
the state now has filed an affidavit and a pleading that claims post-hiring into 2022. And then Mr. Wade
Yeah, they both.
Willis
I mean,
testified
one's a special
to the
prosecutor.
same thing, under oath.
Lies.
Now, Ms. Yerty says it began in 2019. Why would she know? Well, she would know because she was a former friend. I know the state's going to get up here and say, you can't believe, essentially what they're going to say is you can't believe any defense witness because they're defense witnesses. And only people that would tell the truth would be Wade and Willis.
Government
I suggest to
prosecutors.
you that that's not accurate.
Yeah, right.
I suggest that the testimony that Mr. Wade gave and Ms. Willis gave, and I'm specifically dealing now with the timing issue, without getting into anything else, that
Perjury.
brought forth a true concern about their truthfulness and being what is required of a lawyer in this state,
Yep.
which is candor for the tribunal. And that's 3.3 of the professional rules. Specifically, small a1, make a false statement of material fact or law to a tribunal. So that's, as I posited to the court, that's the second ethical violation. And then you also have 8.4 of the professional rules. It says it's a violation of the Georgia Rules of Professional Conduct for a lawyer to, and that's A4, engage in a professional conduct involving dishonesty, fraud, deceit, or misrepresentation. Now, do you have to find that Wade and Willis lied? No. What you need to be able to find is that there is a concern, a legitimate concern based on the evidence in this case about their truthfulness, a legitimate concern about the truthfulness, which equates to an appearance of impropriety.
Mm-hmm.
Because once you have the appearance of impropriety under forensic misconduct, the law in Georgia is clear, that's enough to disqualify.
This is
So,
Robert.
Why
Goldman.
should you
guys
find
know.
there's a concern
Let me drop the link.
with their truthfulness?
He's on.
ERT is the first
This
one.
is his
You have that testimony.
Twitter stream.
But then we go
She owned the condo.
to what is the most obvious indication
Former employee.
Watching the Watchers.
that Willis and Wade were not truthful on the point of timing, and that's Bradley. Defense Exhibit 26 came into evidence. Defense Exhibit 26 comes in and says, and you know I went into this the last hearing. It says that on January the 5th, 2024, at approximately 9:49 a.m., there's text messages that are exchanged between Ms. Merchant and Mr. Bradley.
In
And the
evidence.
text messages go like just date, and that's from Ms. Merchant. Ms. Merchant says, do you think it started before she hired him? Bradley, who we now know from Defense Exhibit 39, has been texting with Ms. Merchant for a number of months.
Even in
This is not the
2024.
first time.
Right.
This
Recently.
is months within the communications between the two. Mr. Bradley says, absolutely.
Yep.
Now, absolutely is not a speculative word.
I don't recall.
That's not speculation.
No.
That's a definitive statement. And Bradley then unprompted as this, and unprompted is important. It started when she left the DA's office and was a judge in South Fulton. It goes on, Ms. Merchant says, she liked it started when she left the DA's office with the appropriate, or whatever one would call it, to say it was liked. And then Mr. Bradley said they met at the municipal court CLE conference. Again, unprompted. He's now
Oh, absolutely,
definitively telling
Michael.
Ms.
I agree.
Merchant when this relationship started.
And it's specific, not magistrate court,
Ms.
municipal
Merchant says,
court.
that's what I figured when he was married. And then Ms. Merchant says, and we're now talking about a couple hours later, she texts and says, upon information and belief, Willis and Wade met while both were serving as magistrate judges and began a romantic relationship at that time.
Here it comes.
And Mr. Bradley responds, no, municipal
Doris.
court. Thank you.
Nice
Doesn't
correction.
say it didn't start then.
No.
He doesn't suggest that she's wrong, other than magistrate court municipal. Now we have that, and it's in evidence. And what does Bradley do? He knows that he's put himself in a position that if he testifies truthfully on the witness stand, Your Honor is in a position to be able to find, if you choose to, that both Willis and Wade lied.
They did.
So what does Bradley do? But you were an assistant U.S. attorney. It works when you have witnesses in this situation. Mr. Bradley did everything he could possibly do
Yep.
to evade answering questions.
Yep.
No recollection, couldn't remember,
All
it was
speculation.
speculation. Anything he could possibly say that would cause Your Honor not to believe that Bradley knew when this relationship started. I suggest they were clear-cut lies. And
Lies.
the truth is in Defense Exhibit 26.
Yes.
And so if we take that view that he thoroughly impeached himself, that he did not give truthful conduct, what's left standing? Generally, you would see someone who's impeached. Perhaps we have some kind of core that you could point back to and say, that's the time he was telling the truth.
Text messages.
In these text messages, is it ever definitively shown how he knew this and that he actually did know it, other than just a
my
assertion
gosh.
outright? Absolutely. Usually, if a state has a witness that goes sideways, they've got him locked in. They've sat down with a detective, got a full statement. We don't have that here.
But what you have is a text message, which is a prior statement of Bradley that he did on his own,
Before he was on the
that
stand.
was not given to him by some. The only thing that the court has just noted is, how do we know he wasn't speculating? Because you don't have to accept the fact that he wasn't speculating. The cases that I provided, I think by email yesterday, the first dealing with that, you can disbelieve that testimony and draw a negative inference. That's the Ferguson case. On Lee, the other case, you can simply take the prior inconsistent statement as substantive evidence.
And the
It has
source,
the same value.
the source
Hey,
was
Midwest.
That's what I'm asking you to do, to take what was the unprompted statement in Defense Exhibit 26 of Bradley and take that on its face value, that is an indication that Bradley in
Got my
fact
jail
knew
cookies.
and had said he did. If you accept that, you have to have concerns about the truthfulness
And it came from
of
Nathan
Willis
Wade.
and Wade on the timing issue.
Bradley
And
got
and
it
I
from
don't know
Wade.
if this is something maybe one of your co-counsel were going to address as well. We heard about kind of the law that applies how we're outside kind of the orbit of the core of cases we're used to dealing with here, where it deals with side switching or where someone is in the relationship, the client relationship.
Never had
Oh,
a
the
fantasy
Bluegrass
before.
Proposition
Fest,
you're
huh?
putting forward
That's
now
cool.
is that if a representative of the state, either the district attorney themselves, says something that's untruthful on the record, that is something that immediately has to be proactively policed by the trial court. Is basically what I'm getting at is where in the
not what
law
he
do we
said.
find the remedy to an untruthful statement? Generally, we send you down the street to the bar, right?
Right.
And that's why I gave you the cases of Registe and Edwards yesterday. While those aren't prosecutorial cases or dealing with prosecutors, they deal with counsel. And in both those cases, the trial judge found ethical violations on the part of
Yeah, I remember you
defense
talking
counsel
about it last
or
year.
potential ethical violations. Went through the ethical violations and said, based on that, you're disqualified.
Where's it at
You
again?
cannot be the attorney of record in this case. What's good for the goose is good for the gander.
So
If defense counsel can be kicked
Ross,
off of
hi.
the case because of ethical violations, I suggest the same thing can happen for prosecutors when the ethical violations deal with
Someone,
truthfulness, candor to the court, extrajudicial statements.
East Peoria.
Those are the things that this court can rely upon and say, based on those, again, I find an appearance of impropriety.
Where would be the limiting principle? District attorney signs every indictment assigned to this courtroom. Does that mean she's off every case?
No, it would be when
If I found that she's untruthful, is that what you're kind of suggesting though?
you don't have to find, again, I'm not saying you have to find she was untruthful or that Wade was untruthful. You don't have to make a finding of fact that they lied. All you have to
You
do is make
should.
a finding of fact that you have genuine, legitimate concerns about their credibility, about their truthfulness. And once you find that, then you can apply Registe and Edwards.
Well, but it's the same principle though. If I have genuine concerns about her truthfulness on a particular occasion, how do those not spill over into
Yeah.
every criminal case a district attorney brings?
this
Well,
is
it's
why
because she testified under oath, and so did Mr. Wade. They didn't have to testify falsely. They could have testified truthfully. They could have indicated that the relationship, the timing was in fact before Mr. Wade was hired. They chose not to. And in that sense, that dishonesty, that constitutes a violation of their ethical responsibilities. This is not signing an indictment. This is not filing a pleading in which both sides have their own positions. This is a requirement that every witness has to tell the truth under oath. And if they don't tell the truth, or there's a significant concern about their credibility, then they're violating their ethical rules. And as anyone will tell you, as Your Honor already knew from when you were a prosecutor, prosecutors are held to a higher standard.
yes, they're supposed to be.
They're the ones that are supposed to be seeking justice. They don't have a particular, they're supposed to be disinterested. When you have the lead prosecutor and the DA giving, what I suggest to you is
Say it. Lies.
Sounds good. Midwest.
untruthful testimony
Lies.
based on what Yerty has said, based on what
Actually, that
Bradley
makes
said
me
in
want
his
to
text,
check.
I'll say it for
based
him.
on the whole way it was presented to you. Bradley didn't want to testify. He first came up with his attorney-client privilege thing on that. Then Your Honor was, fortunately, went into that. And then when Bradley knew he had to testify about it, you saw what happened. You can draw the inference, as I've suggested on Bradley, that what he said in the text message, Defense Exhibit 26, is true. The relationship in fact started prior to November 1st of 2021, that Yerty says that. And now, without getting into any detail, the cell phone records. The cell phone records show that during that period of time from, let's say, April 1, 2021 to November 30th of 2021, that there was a considerable number of 35 or more occasions where it
Fanny
appeared
calls.
that,
Fanny calls.
based on the records, that Mr. Wade was down in the area where Miss Willis was staying in Yerte's apartment. But more important is there are 2 occasions, and the state has not challenged those. There are 2 occasions where the records reflect that it appears Mr. Wade spent the night at that apartment. The state may say, we don't accept that, but they didn't challenge it. And even when they brought forth what they brought forth today, supplemental 2 and 3, they didn't challenge it again.
Nope, they didn't.
So what does that suggest? That's corroborating evidence of what Yerte had said, of what Bradley said in his text message. It's also impeachment evidence as to what Wade and Willis said about how many times.
Is that a significant in terms of just the times? Didn't Mr. Wade testify that he was there at least 10 times during that time frame? You've now found 35.
Well, minimum of 35,
Okay.
but never overnight. He said he never spent overnight.
Put that to the side though, just in terms of the fact that he'd been over there, that he'd visited the place, and I would presume he wasn't obviously keeping a very good accounting of it, but that wasn't something that was entirely denied.
If you're asking me, do we win on the point that he said more than 10 or around 10 and we say 35, do we win on that point?
Sure.
No,
Okay.
it's not determined.
The overnight rate might raise some more concerns.
Yeah,
Understood.
it does. And that's the reason why we highlighted it in the affidavit of Mr. Middlestat.
It's
Because
dishonesty.
that is suggestive that they were not being honest to the court.
Yes, Judge.
So then, let's see, how much time have I used? Too much. Have I?
I'm letting them use the hook. So, suggestive, again, raising issues. I'm wondering about burden. Is it we're dealing with a preponderance standard?
We are dealing with preponderance standard and it's our burden.
Yeah.
No question about that.
So does
But-
suggestive get us there?
No, but it is corroborating evidence of evidence that we did put up. And that's what the purpose of the cell phone records. They corroborate what Yerte says. They corroborate what Bradley said in Defense Exhibit 26.
And they go.
And they impeach
Yes, Wade.
to that extent Wade and Willis's testimony.
Yep.
So if you find by a preponderance of the evidence, if you find by a preponderance of the evidence,
More likely
that-
than not.
what I call subset of forensic misconduct, ethical violations has been shown, and that there is a significant and legitimate concern about the truthfulness of Wade and Willis, they're disqualified. Now, obviously, the factual findings are yours, but the law allows you to do that. You don't have to do it through an actual conflict. That's the other side of the equation. And that's what I've argued, and I think that's what Mr. Gillen's going to argue.
Before I let you go though, this is an interesting classification. You're saying forensic conduct isn't just commenting publicly about the case indicating guilt. You're saying forensic conduct is just anything a district attorney says
No.
falls into that box?
No, I'm saying that
Improper,
that
obviously.
forensic misconduct as a subset of that would include violations, ethical violations
That he went
which
through.
impact the ability of the defendant to get a fair trial,
Right. I
as
just asked
well
for an
as
update.
impact the court's ability to have
That
faith.
FOIA request.
Prosecutors, these 2 prosecutors are acting in good faith in their own conduct. Same idea dealing with, as I said, defense counsel in the 2 cases I mentioned. Ethical
All right,
violations
Gillen's like,
can give rise to disqualification.
it's my turn. Get the
and I
hell
said-
out of here.
All right. Thank you, Mr. Sano.
Thank you.
Okay. So this judge is doing some normal stuff, right? He's trying to poke
Where's the
holes
shot clock when you need it?
Right there.
right there.
Your Honor, I want to address very directly here. What we have is a systematic, continuous pattern, a calculated plan, evidencing a design to prejudice the defendants in this case,
That's right.
in the minds of the jurors. This is what we have seen. This isn't the problem that the.
Well, this
district
judge actually
attorney
was a
has. It's
subordinate
not
of
that the
Fannie
district attorney
Willis at one
had
point.
some sort of brief, off-the-cuff statement.
Probably
and
should have been stated at
interaction
the
with a
beginning of the
reporter
case. But
like in Williams. That's not what we have here. We have someone who sat down, wrote out her
I think he
speech,
even donated to
wrote
her
out her
campaign.
plan, who sat down for whether it's 2, 3, or 6 times with the editors of Find Me the Votes and told and got her message out about this case
But
before it was
the
supposed to be
spotlight is
tried
on him.
in
So
this courtroom. And so that is the problem that we have. We have a pattern of forensic misconduct on behalf of Miss Willis.
So
Now,
Harold, he's
you-
going to
we
do
have
it
a
to the other
pattern of
side too.
public statements being made. I take it you or your team has dived in and read the book. I know she was asked about specific portions in it. The only case that I can find actually talking about when someone crosses the line on public comments is that Williams case, and it talks about there has to be an implication of saying a particular defendant is guilty, and it even denied it, right? So, have you found any case in Georgia where they actually said that a prosecutor had gone too far in their public comments? Does one exist?
well, number one, thank goodness it doesn't happen often.
Yeah, we don't have
Sadly,
a lot
it's
of
already
big
happened
fannies.
here.
Yeah.
Now, in Williams, the prosecutor had one response to an inquiry. The court found it was improper, but did not have this pattern. Now, it doesn't necessarily mean a comment about the quote guilt or innocence, although that was the pattern in Williams. It's the improper comments by a prosecutor. For example, in Williams, they cite the nature and consequences of forensic misconduct in prosecution of criminal case, a 1955 Columbia Law School article, and how prophetic that was. When Williams cites that case in that law school, they talk about an awful lot more than simply the comments about specific guilt or references to guilt. What you have here, Your Honor, is a comment, and we can't look at it doesn't apply only if a prosecutor said, I think the defendant is guilty in my mind. No, it's more pernicious than that. What we have here is someone who sat down and drew up a plan for two reasons. And what she did reminds me of what the court in STV, Texas talks about, and that is that pretrial can create major problems for defendant, indeed more harmful than publicity during a trial, for it may set the community opinion as to guilt or
Exactly.
innocence.
Programming
That's
the
what
jury.
we have here. That's exactly what we have. And the court in STs talks about the power of the television camera. So what
And the
what
prosecutor.
do we have, and what did this prosecutor do? What she chose to do is sort of what was criticized by the Supreme Court in Shepard v. Maxwell. Legal trials are not like elections to be won through the use of meeting halls or the newspaper. That's exactly what we have here. What we have is a deflection. What this is all about is more insidious than just making the comments that she's made. It's a deflection. What she chose to do was to say, okay, I have done my best to hide the relationship with Nathan Wade.
It was a
And Nathan
cover-up.
Wade has done his very best by filing false documents in his divorce case to
Misconduct on
hide
top
his
of
relationship
misconduct.
with Miss Willis. Now, and so what did they do? Well, when Miss Merchant filed the motion to disqualify, now the game plan has to change. The game plan I call the deflection begins to take place. The deflection is when the district attorney sat down and wrote out. Look at I'm sure the court has. When you look at that video, it's in evidence of her speech at church. She has written out everything and she's reading from it. She chooses to deflect. The court asked earlier, wasn't she really responding to the motion that had been filed against her? Would that she had, because if she had, she would have looked the members of that case and say, there's been an allegation that I had a romantic relationship with Mr. Wade. And ladies and gentlemen of this congregation, it's true. She didn't do that. She chose to deflect and to do two things that are reprehensible.
Yes.
For any lawyer, but particularly for a prosecutor. She
The
chose
DA.
to pull out the race card and the God card.
Yep.
That's what she did.
To a
And she
bunch of
wrote it
jurors.
out. She went on to deflect away from the allegations in the Wade motion. And she said, she's saying, why, in her talk, public discussion with
God?
God, why are they only attacking one?
'Cause
In
you slept
reference
with
to
him.
Mr.
That's why.
Wade.
Not
And
complicated.
then she goes on to say, God, isn't it them playing the race card when they only
No.
question one?
No.
Now, if she had been truthful with that congregation, truthful with the community, she would have
And
said,
truthful
I
with
had a
God.
relationship with him. Good, bad, forgive me, whatever. That's what she should have said.
She
But
didn't.
she chose to deflect and say them, the reference to them and the others and they. It's obviously a reference to the by Miss Merchant.
Clearly.
They choose to go after the black man.
Yeah.
And she then goes on
boyfriend.
again, deflecting away and deflecting to what I call the third rail in American society, choosing somebody on the other side of being a racist. So-and-so is a
Disgusting.
racist. They're
Yep.
racist.
Yep.
She was the one playing the race card in a way to try to deflect from her own conduct.
Misconduct on misconduct.
She goes on to say in discussions with the Lord, God, is it that some will never see a black man as qualified no matter his achievements? Again, the deflection. What is she saying? The listener is not necessarily in that audience in that church. The listener is at Fulton County. The potential jurors who will come into a courtroom and say whether or not they can fairly judge the evidence or judge the defense in this case. She chose to inject race into the minds of the listeners and virtually everybody in this community, and literally everybody in this country has reviewed and analyzed her speech that she made in a premeditated way. And in not only the race card, but also in bringing in the religious matter. This is exactly what Hammonds v. State and our Supreme Court talks about, condemning as an inflammatory appeal to the jurors' private religious beliefs. Why would she do that? To deflect. But now, not only is she deflecting, but she is then going forward and in a way telling the community, telling the congregation that God is on her side,
Yeah.
not on the side of these people.
Right. Those evil racists.
God, she said, and when she's talking, and she's saying, God, pray for their souls. I, meaning God, qualified you. I qualified your imperfect, flawed self. I see you in every hour. Do my work.
Wild.
As though she's telling the folks in her very, very, very implicit way, injecting into the minds of the jurors, God wants me to win this case. God wants me to prosecute this case. And why is he going, and why are these others going after the black man? Well, the answer is very simple. As we said in our brief, we didn't mention
You
Mrs.
slept with
Cross,
him. That's why.
Cross, the white female, or Mr. Floyd, the white male, because there was absolutely no evidence and is no evidence of a personal romantic relationship with them in which he
Very
obtained these benefits. That's the reason
I'm
why
actually
we,
chatting in his.
we
He's
did
streaming
not,
this on several
do that.
several
So
platforms as well.
she goes
I'm
forward
chatting in
with
his
her
Rumble.
with the deflections. That's exactly what she does when she goes forward and she talks about a planned interviews time and time again with authors of a book, Find Me the Votes, where she's talking about a case that's going to be tried in this courtroom. It's reprehensible.
So in that specific, instance, setting aside the fact that she was willing to go on the record before a case had even reached the jury, what specific statements from that book do you contend cross the line?
Well,
book.
for example, she's saying, she goes on to talk about all the calls that she gets from people calling her racial terms. And all the calls are racist. What she's trying to do, and I think there's a reference in there to MAGA people, whatever. In that, what
Of
she's really
course.
saying is that those people calling me up and making those claims or those horrible are really people on their side of the fence. That's what she's doing. And there's no reason, Your Honor, ever for a prosecutor to sit down and go forward with this
No.
kind of interview. She did it in
Yes.
Find the Votes. But then what really happened here is this hiding of the relationship. Because in hiding the relationship, they have done such a good job. Mr.
Okay.
Wade filed false documents in his divorce case.
Yeah, in his
When,
interrogatories.
On May the 23rd, May of 2023,
Yep.
talking about, have you ever had sexual relations with a person during the
Um,
course of marriage
No.
or including the
Yeah,
period
yeah,
of
I set it up.
separation? He's still married.
Everything at the
He
main,
doesn't have a divorce decree,
the Legends
but his
facility
answer is none.
wireless.
Then he's asked whether or not on
So
any
I set
occasions
up
he's
a-
entertained or been
like
entertained
a commercial
by
type,
by
wireless
someone,
where,
a woman,
like hotels use.
a member of the opposite sex, in this case, a woman.
I literally,
the
Another
date of
one.
the
you can,
marriage
with
to
the
the
type of
present.
system that we're using, you can run up to
Talking
like
about place and
300
time
devices.
and all that. What is the answer? None. Why does he do that? He
Cover up.
does that because he doesn't
Most new
want to
TVs
tell
are
about the
wireless.
relationship
Almost
that he
any
has
TV.
with
I
Miss
mean,
Willis
Roku would
and the
be a
benefits
better way to
that
go
he has
than some of
gotten
the
and that he gave to
like
her.
Windows
Amen.
type Android
Right on.
TVs.
And what these
That's it.
answers
And he's a
are
lawyer, so
absolutely
he knows.
reprehensible that a
That's
member of the
something that
State
I
Bar of
wasn't asked
Georgia
when they
would
purchased a bunch
file
of
these
that
answers
facility.
true.
So
that are
when someone
that
hits
are
the remote, it
inaccurate.
changes
a-
like
what
eight
does,
TVs.
Flagrant lie.
What does Miss Wade do? Excuse me, Miss Willis do? Miss Willis, on her financial report,
Great.
on whether or not she has gotten anything of $100 or more in value.
Yeah, just make sure it's
from,
and plus
Another
when
one.
you do, make sure it's the
prohibited
type with
source.
not just the
The court
wireless
asked
remote,
earlier
but the
about what a
type with
threshold might
the
be.
actual
Well,
infrared.
for the financial
You know what I mean?
report, it's
Where
$100.
it
That's it.
beams the signal to
He doesn't
the wireless.
report any.
You
of
can
all
still you
of the
can
benefits
individually pair them,
that,
but every time
that-
a battery is
that she
changed or
received
something like
from
that,
Mr.
it
Wade.
unpairs. And
All
it's
the trips,
something we've run into.
all
and
the
we definitely know
entertainment,
what direction
all
we're going as we have to
the
replace them because
the 3 nights in the luxury suite
Yeah.
in
Napa
Aruba,
Valley.
all of that.
yeah,
None
IR,
of
yeah,
that
well,
is
IR
allowed.
remotes.
And they
yeah.
say,
Miami.
oh, well, maybe it all balanced out, even though I can't prove it with the cash.
No,
Well, that's like saying, did I give the court a Christmas present?
time to punch in.
Well, maybe I gave the court a
Later,
Christmas
Doris.
present, and the court gave me one
Should
back.
be here for a
The
bit.
court has to fill out a form whether you got a Christmas present.
I'm not using
from
my
anybody.
earbuds just
You say, I
because
got one from
I'm
Mr.
not sure
Gillen.
why they're not working
You don't
very
say,
well.
nah,
We're
well,
not
I gave
holding
him
in
one
charge.
back, so it really.
So if you
evens
guys are
out.
getting a lot of echo,
They're
let me know.
ridiculous.
Hey, Tapio's.
And because they're false, what they had to do is they had to say, Miss Merchant has caught us. And so what we're going to do is we're going to get, in our response,
Nathan's
we're going to get
whispering.
Mr. Wade to file a false declaration, which he does.
He
His
does.
declaration in this case is false. And
Lies.
the evidence showing that that is false as it relates to the timing, and the court asked earlier, why does it matter, if the relationship was before or after November 1, 2021? The answer is they think it's important. And frankly, I do too, because when she's hiring somebody and she's not telling the people who are going to be paying the tab up to $700,000,
Yeah.
hey,
Over that now.
I just hired my boyfriend who's taking me on trip to the Caribbean and taking me down to Aruba and taking me to California.
Crazy.
Hope you don't mind. No disclosure.
And he's getting
whatsoever.
paid more than
The money
anybody
flows
else.
off. But because they got caught, they then commit what I think is an additional component of forensic misconduct,
Yep.
and that is fraud on this court.
Yes. Said
When
it.
when they filed that affidavit, and now it's been proven, I think, beyond virtually any doubt that the relationship occurred November 1, 2021,
Lies.
and the benefits that were there. And we don't have to run around. And I love we've got all the records showing from Mr. Wade about the payment for these trips, for the cruises, for the flights, all this stuff. What's the only way is they sat around and met together before they testified and came up with their story. What's the
Cash.
only way that they can save themselves? Pay no attention to the records. Pay no attention to the airlines and to the flights and vacations and the cruises. I paid him back in cash.
Mm-hmm.
Show us your receipts. Where did you
Don't have
take
any.
cash out of the bank?
Did you deposit it?
Ever?
No.
Oh, I don't have any. Well, show us the deposits
Nope.
that he had.
Don't
Well, never. We don't have any. What we have here is a fraud on this court, which has been shown, I think, overwhelmingly by the evidence and overwhelmingly through not only the testimony of Yurdi, the testimony of the emails and the text from Mr. Bradley to Ms. Merchant, as well as all the documents that they had no answer to other than the just trust me, gave him money, it evaporated. I don't know where it came from,
Yeah, it's gone.
and he doesn't know what he did with it. Just please trust us. and believe us because it's our only way out
Yeah.
of the trap that they set for
Yeah, we're
themselves.
prosecutors.
These people, sadly, and I hate to say I was a former,
Let's get
as the
it.
court knows, I was a prosecutor for about
Say it.
3.5 million years, it seems,
Say it.
in the federal building, and I was an assistant DA beforehand. Prosecutors don't act like this.
Yes.
Lawyers don't act like this.
Yes.
These people, Your Honor, is a systematic misconduct,
Yes.
and they need to go.
Yes.
Thank you.
Yes. Yes.
Yeah,
Mr.
Rob's getting
Gillis.
excited.
Calling them out and laying it all down as he should. Absolutely true. It's disgusting, reprehensible behavior. And finally, someone
Your
called
Honor, I'm
them
going to
out
cover
right in front
a
of their
few
faces.
factual details without overly rehashing what has already been said. During the pendency of this investigation in this case, Mr. Wade and Ms. Willis basically lived Robin Leach's lifestyle of the rich and famous. And they did this riding on the backs of the defendants in this case, funded by the taxpayers of Fulton County and the
Yep.
state of Georgia.
Exploiting
With the money
defendants.
This is hilarious.
that was Mr. Wade through the contract that Ms. Willis got him. That money flow, that is the personal interest that you asked about.
Yep.
She was personally benefiting from the position, from the job, from the scope of the investigation, from the scope of the indictment and how they conducted it.
And the companionship.
And we know this, we know from the records that have been submitted before the court that Mr. Wade paid at least $17,095 towards this relationship. That does not even include the various dinners, the day trips that both Wade and Willis admitted to. So that number is likely even higher. We know from the documents that Ms. Willis only paid $1,394 for an airline ticket.
Yeah, there's a benefit clearly.
We know from Ms. Yurdy, who was pretty much uncontested. There was no evidence presented by the state disputing her time frame that relationship started in 2019. She saw them kissing, she saw them hugging. Now, whether or not they had sex before January of 2022, I do not know. They admitted sometime in early 2022, and I found it curious that Wade and Willis just went straight to the sex. So maybe that's when they started having sex. I do not know. But the relationship predated that.
Yeah.
And their combined
It was at the
and
conference.
overly suggestive focus on that.
I know
is
what
a
goes
red
on at those
herring to this court
conferences.
and to
Okay.
the defense, that's what they want you to focus on. They want you to ignore all the evidence that the relationship predated that. The relationship started in 2019.
With they had
The
their robes
relationship
on.
continued through 2020. The relationship continued through 2021. Looking at the cell phone communications, just in the first 11 months of 2021, over 2,000 calls, almost 9,800 texts. You know, I don't even think love-struck teenagers communicate that much.
No, that's a lot.
The November 29th,
Got work
and
to do,
November
man.
30th escapade. Phone call from Miss Willis, between Mr. Willis and Mr. Wade, 11:32 that night.
Booty call, fanny call.
Shortly after midnight, the phone starts traveling down from where Mr. Wade lives and ends up where Miss Willis is staying. And he's there
For an overnight.
until roughly 4:55 a.m.
Ooh.
None of the excuses, none of the explanations that Mr. Wade gave, experience, going to dinner, going to the airport, none of that explains that.
Porsche experience.
I'm
Yeah.
pretty sure the Porsche experience isn't open in the middle of the night.
I don't think so.
I'm pretty sure that there weren't any restaurants that he drove 30 to 45 minutes to go eat at.
At
in the middle of
3:30 in the
night,
morning.
right
Yeah.
after he talked to Miss Willis.
Yeah.
Um,
They were indicting each
Yeah,
other.
you're
Teenagers
doing
have a name
stopwatch,
for those
stop.
kind of calls and those kind of escapades. I won't go into it.
Booty
Um,
fanny
but
call. It's a
The
fanny call.
documentary evidence, the objective evidence, undercuts everything that both Wade and Willis said. When you look at
here
Miss
if you want.
Yuri,
Here, wait, let me.
again, she
make it so
unequivocally
you can-
said that relationship began in 2019. She saw physical evidence of a romantic relationship. Mr. Bradley,
You can drop here
in
if
the
you want.
text messages, which are substantive evidence, said that relationship began in 2019. Again, his January temporary amnesia
Yeah.
that somehow was triggered temporarily after Gabe Banks called him.
Weird. Yeah. Weird.
We can question that.
I don't
But we do
recall.
have statements from him that specifically said that relationship predated Mr. Wade's appointment.
And it matches
Um,
Unity.
You asked, well, and Mr. Wade, you asked what the materiality would be. How much is enough? Well, clearly 17,000 is enough. But Fulton County has told Mrs. Willis what the materiality is. It's $100 in a year.
Fire.
She twice signed declarations, certifications that she did not receive any gifts. And even under her
Is this that,
strained,
Civil rights
her
organization. This is the one
strained
that
explanation,
Jeff Gray was working with,
there
right?
were monies, there were gifts, there were
Georgia?
dinners, there were excess contributions flowing her way that exceeded $100. Her excuse, or I'm sorry, her explanation, well, I just paid it in cash.
Yeah. Strong, independent woman.
That
You
just
don't need no man.
does not stand to reason. It does not hold up to the light of truth.
And Wade's a
um,
bigot.
Anyone that
Sexist.
has ever been in a money laundering trial, a forfeiture trial, if that's the explanation we give the state, they laugh.
Of course. It's
Oh,
ridiculous.
I just gave cash. I have no records for it. I have no source for it. The only thing that
innocent.
she could say that was the source for the money said she was down to $500 to $1,000. The only explanation she have is, well, sometimes I go to Publix and I may get an extra $50.
You're right.
That shows up on your debit card.
Would
or
you
your
like
credit
cash
card.
back with that?
Did they bring those records in? No. They bring her bank accounts in? No. Did they bring any documentary
No.
evidence in? No, they did not. And why is that important, Judge? Yes, the burden is ours. But under OCGA 24-14-22, if a party has evidence in such party's power and within such party's reach, by which he or she may repel a claim, and they had that power, Ms. Willis had that power, Mr. Wade had that power, that they can repel the claim that we have made against them, but they admit to produce it, or if they produce weaker evidence, then you, as the fact finder judge, it is in your power to disregard that, and a presumption arises that that documentary evidence that is in their possession that they failed to produce supports our claim.
We're talking about burden of proof here.
And that is something that the state relies on regularly in criminal trials. And that is something that the court should rely on in this case when formulating its factual findings.
Who has the burden?
That both Mr. Wade and Ms. Willis have some difficulty expressing the truth when it comes to their relationship in these cases.
A lot of
We know
difficulty.
Mr. Wade lied in his interrogatories multiple times. We know Ms. Willis falsely certified that she hadn't received any gifts from anybody. And Mr. Wade clearly was a prohibited source. He was someone doing business with Fulton County. Anything over $100 in a year, she had to put down, and she put zero. And it
And they lied
defies
about it.
imagination that she could somehow forget about all these trips, all these dinners, all these day trips,
Total cover up.
and not put that money down. You had asked, I think it was Mr. Gillen, did she say in that church speech or anywhere else that the defendants were guilty? And I think she did in that church speech.
I got a
She
pug
said in that
snoring
church
behind me.
speech, and she was talking about a conversation that she apparently had with God, talking about herself. She said, this leader has a trial conviction rate of 95%. She said, the trial team this leader put together has a conviction rate of 95%. I do not see how anyone was purposefully intended by Ms. Willis. I do not see how anyone can listen to those two statements and not take that Ms. Willis is telling everyone in that church and everyone that's going to hear that in the media afterwards that these defendants are guilty. That is what she was saying. She is a prosecutor. She's familiar with the U.S. v. Berger. Every single attorney that's ever been a prosecutor is familiar with the dictates of that U.S. Supreme Court case.
Dictate.
That is a foul blow. That is improper, and she violated pretty much every tenet a prosecutor must abide by to seek truth and justice in a particular case.
She's Fanny, biggest Fanny in Georgia. She can do whatever she wants all
So
the time.
Judge, when you're looking at this, the uncontroverted evidence shows that they had a relationship prior. The uncontroverted evidence shows that Mr. Wade lavishly spent on Miss Willis.
Yes.
The uncontroverted evidence shows that the money that he was spending on Miss Willis came from this contract that he had. And I'm not just talking about the contract as a special prosecutor, but there's also those other questionable contracts that no matter whom his partner seemed to be, so got.
They got him. Yeah.
There is a
Total
direct
corrupt.
financial benefit that Miss Willis received from this. And Judge, looking back at what Judge McBurney said, if merely hosting a fundraiser for a political opponent of a putative defendant
How'd it go for Jeff?
creates not only
He
the
won.
appearance, but an actual conflict,
He won.
then what Miss Willis has done since then, in this case, creates an actual conflict. But again,
I think he just
as the prior
wanted,
counsel has stated, we only need to show the appearance of a conflict.
like
And we have done that. by a
$1,700,
preponderance of the evidence. In
1776
fact, I
or
believe
something like
we've
that.
shown an actual conflict. But nonetheless, the
Beyond a
result
reasonable
should
doubt,
be
too.
that Miss Willis and her office should be disqualified from this case. We still have a few more minutes. I think Mr. Cromwell may have something to say.
Well done.
Thank you, Your Honor.
Yeah,
Okay,
Jeff
so
won.
a lot of conversation about the burden of proof. And remember, this is a little
And
strange
that's what he's
because
proffering
burden of
to
proof in a criminal
all these other ones
prosecution
in
rests on
Alabama
the
and
government.
Mississippi too
The
that
government
Good afternoon, Your
is on
Honor.
the
Legally,
defense now.
Harry McDougald for Mr. Clark.
trespassed him.
I'm going to talk further about conflicts, and I'm going to assume the most difficult
Go to the
standard
bathroom,
for us
guys.
to meet with full conflict.
But I don't want to
Actual
miss this.
conflict.
But before I begin that, I want to add just a little bit to what has already been said about the standards that apply to prosecutors. Our appellate courts have said often, the administration of the law, and especially that of the criminal law, should, like Caesar's wife, be above suspicion and should be free from all temptation, bias, or prejudice so far as it is possible for our courts to accomplish it.
Good luck with
The
that,
first
Fanny.
Yeah, right.
Occurrence of that I can find is Nichols v. State more than 100 years ago, 1915. The most recent, Registe v.
I think they're going
State
to take a
in the
break
Supreme
after
Court
the
in 2010, although they don't refer to
defense
Caesar's wife.
finishes their.
That
arguments.
requirement is also embedded in the
They've
prosecutor's
got 90 minutes of
statutory oath,
argument, and then the state gets a whole 90
15-18-2,
minutes as well.
which requires impartially and without fear or favor discharge my duties as district attorney and take only my lawful compensation, so help me God.
So some color here, right? We get a little flavor.
The general rule on conflicts
Caesar
of
and other
interest
things.
for lawyers is in Rule of Professional Conduct 1.7. And we all know, it's all drummed into us, that we cannot have a conflict of interest.
I understand that.
And
I don't have
we do, we
earphones.
have to withdraw or we will be disqualified.
Totally true. And it's a big thing
The
for lawyers.
basic idea is that a conflict of interest impairs the lawyer's independent professional judgment. That's the
I do,
test
but they're not working.
of
right.
a conflict and whether it can be waived and whether it's disqualifying. And that conflict is not just
Yeah, I'll just have to
financial. It
mute
can
them when
be
I'm talking.
any
It's my
conflict
bad.
that impairs.
Yeah, my
your
earbuds are acting
independent
weird. They're
professional
not charging
judgment.
right.
And you see that in McLaughlin v. Payne. The court asked what was a personal interest for purposes of disqualification. It's anything that impairs professional judgment. That's reflected in the ABA standards that were quoted by Mr.
I'll be right back.
Merchant,
I gotta go to the
which
bathroom.
list the prosecutor's personal, political, financial, professional, business, property, or other interests or relationships. And that's really embedded in the prosecutor's oath to act impartially. And the earlier disqualification order by Judge McBurney was based on political interests, not financial. What my colleagues have described as forensic misconduct is also cognizable as a conflict of interest. Footnote in Williams' case. The root of all of the problems that we see in this court right now is a conflict of interest arising from their individual personal interests
Yes.
in perpetuating and concealing their relationship.
Yes.
That's the original sin
Yep.
from which all of the other problems flow.
They could have come clean.
There are 6 different actual conflicts of interest in this case, any one of which warrants disqualification,
go,
but
6.
collectively practically compelling. First, the financial conflict that's already been covered. Second, the personal ambition, political ambition. Third, there's a dovetailed or complementary pattern of deceit and concealment
Yep,
of the
cover up.
relationship and the money.
Which is not
Fourth,
good.
the speech at the church. Fifth, the motion for protective order that the DA filed in Mr. Wade's divorce case. Sixth, the way the state has conducted the defense
Yeah.
of this motion to
Asking
disqualify,
for sanctions
especially
for
the hearing.
Ashley. Disgusting.
On the financial piece, the court asked for a limiting principle and asked about materiality. The limiting principle pairs the independent professional judgment of the lawyer that is applied routinely. We have a county code section that flatly prohibits gifts from contractors. Period.
That's the
We
limiting
have,
principle. Here
by
you go, Judge.
analogy, the federal bribery statute,
Here
which
you
has a
go.
threshold of
That's good.
$5,000, 18 USC 666.
5,000 with the feds.
The court asked about burdens and inferences. The court can draw a negative inference from the state's failure to produce evidence to support the invisible magic cash balancing theory
Yes.
based on State v. Thomas,
Magic cash.
311 Georgia 407,
It's invisible.
particularly footnote 19. As to the timing question that the court asked about, there were 2 contracts for Mr. Wade executed after they acknowledged the relationship began. Each one of them afflicted or conflicted under county and common law.
Yep. There you
The
go.
second conflict is her political ambition, for which she was previously chastised by Judge McBurney. And that's also present in this book.
Held up the book.
The
Love it.
inside book says that they were given, quote, exclusive access to thousands of secret documents, emails, text messages,
This is good.
and audio recordings. The court has twice denied defense motions to unseal special purpose grand jury materials. She helped herself to get the glory of this book.
Yes, she did.
I
Good.
introduced certified copies of a number of county code sections. I'm not going to walk through those, but I'll tell you why they matter. The stack of law from the state constitution down to the county ordinances imposes a regime on the DA under which she has 3 obligations. She has to go to the county commission to get approval to pay him like she did. She cannot accept gifts from a prohibited source.
Didn't do any of that.
She has to disclose the gifts that she received. She evaded all of those requirements.
Yep.
Section 2-69 of the county code prohibited sources, which he was, there's no boyfriend exception.
No, there isn't. This
The
guy's plugging
disclosure
holes.
forms,
He's
the
cleaning up.
evidence is sufficient for you to find that her disclosure form for 2022 is false
Yep.
and that it is a false writing. That's an actual conflict of interest between her duty, legal duty of disclosure, her legal duty of candor as a prosecutor, and her private and personal interests in concealing the relationship, concealing the gifts, and keeping the gravy train rolling for as long as possible.
Totally. More
His
cruises.
part in the pattern of concealment is a story you see in many divorce cases. The husband is hiding things from his wife.
Totally.
How much money he's making, the other woman, and what he's spending on the other woman.
Yeah, Nathan, talking about you
And he
there.
got on that stand. He lied in his interrogatories, and he got on the stand and he lied about lying in the interrogatories.
Yes, he did.
And the lawyers for the DA's office, they just sat there and let him do it.
Yes, they did.
They did nothing to correct obviously perjured testimony.
Amazing.
In and of its qualification of every one of them.
Yes, yes.
The reason they lied and covered it up was to avoid the trouble they're in right now.
Yep. In your
That
courtroom,
served their
Judge.
personal interests to the detriment of their public duties as prosecutors. The speech at the church. I want to focus on why she did that. Mr. Gillen talked about that. She did it to deflect attention from her own misconduct and that of Mr. Wade. She violated her public duty as a prosecutor to serve her personal interests and the personal interests of her boyfriend. That is a disqualifying conflict
Yes.
between her personal interests and her public duty that is actual, operational, and materialized, and it rests on undisputed facts. The next thing that she did that was a disqualifying conflict of interest was the emergency motion for protective order that she filed in the divorce.
Yep.
I filed a certified copy of that as Exhibit 37.
Why is
She
her
sought a
office
protective order under the Apex doctrine.
intervening
grounds
in
that
Wade's
she's the
divorce?
DA. And the whole filing is expressly predicated on her status as DA.
Yep.
In fact, she
And-
never lets you forget it. She says it 27 times in 12 pages.
And she threatens to charge
In that
people.
filing, speaking as DA, she said,
Yes.
the circumstances, quote, suggest that defendant Joycelyn Wade is using the legal process to harass and embarrass District Attorney Willis,
And interfere.
and in doing so is obstructing and interfering with an ongoing criminal investigation.
Love it. Love it.
In the prayer for relief on page 11, she asked for 6 months to, quote, complete a review of the filings in the instant case, investigate and depose relevant witnesses with regard to the interference and obstruction this motion contends. There's no sugarcoating it.
No.
That's a clear violation of Rule of Professional Conduct 3.4H, which prohibits lawyers from making threats of criminal prosecution to gain advantage in a civil case.
So disgusting.
She abused her power. She abused her position to threaten her boyfriend's wife with criminal prosecution to gain advantage for herself and her boyfriend in her boyfriend's divorce.
And maybe doing the
She
same thing with
violated her
Terrence
public
Bradley.
duties not to make that.
Why
in
did
order to
Bradley
serve
flip?
her private personal interests and those of Mr. Wade. Another actual operational conflict. The last category is the conduct of the defense of this hearing. There were a lot of objections made based on attorney-client privilege during Mr. Bradley's testimony. Most of those objections were made by the state. But the privilege being asserted does not belong to the state. It belongs to Mr. Wade. That shows that the DA's office is serving the personal interests
Mr.
of the
Wade.
DA and Mr. Wade
Yes.
in carrying out further concealment and cover-up of their relationship, and not the cause of justice they are sworn to serve. That is a conflict of interest. It's a continuation of the wrongful pattern of concealment and cover-up that they've engaged in since the beginning.
Love it.
But now they've enlisted the entire office in the enterprise.
And they put perjurers up on the
In the
stand.
written response to the motion to disqualify, they said this, and I quote, "To be absolutely clear, there is evidence that DA Willis derived any financial benefit from Mr. Wade." That's on page 15. Flat out false.
Yep.
10 lawyers in this case put their name on that, starting with the DA. So throw another log on the bonfire of conflicts of interest. The problem here is the DA cannot distinguish between her personal interests and ambitions on the one hand, and her public duties as a prosecutor on the other, and apparently neither can anyone else in their office. Of the 6 conflicts I've identified, only one is subject to a conflict in the evidence. This is a case study in what happens when you operate under a conflict of interest. It's put an irreparable stain on the case. Think of the message that would be sent if they were not disqualified.
Yes, Judge. Think about
If
that.
this is tolerated, we'll get more of it.
Yep.
This office is a global laughingstock
That's
because of
true.
their conduct.
They invented Fanny Call, Booty call is now Fanny call. That's how bad it is. They invented a whole
They
new
should be
word.
disqualified.
Call of
They
booty.
should be
Yes, it should.
Call of
Dismiss
booty.
the case. This has been
There's not
excellent.
much oxygen left in the room. We delineated the times based on the whole presentation. Would Your Honor consider some time for us in rebuttal?
No.
Okay, well then, can I reserve what I had, 5 minutes for
Sure,
rebuttal?
that's fine.
All right, thank you, Your Honor.
All right, let's take a quick 5 and we'll be back at 2:40-ish to hear from the state. Thank you.
So, my friends, man, this has been very good. So, we're also going to pause and do a quick. All right, sorry, Judge. Oh, sorry about that. Stand up, everybody. Put your phone down. All right, judges. All right, sorry about that, Judge. I was excited to debrief the case. All right, please be seated. Okay, my friend. So that was actually very, very good. And you see how this broke down, right? They all just came out, and the judge was asking some hole poking questions at the very outset, which I think is very normal. This is a little bit unusual because it almost has like an appellate format, right? The judge doesn't even really know what the law is because this is a case of first impression. Never seen something like this in Georgia before.
Hey, D News. Good to see you, buddy.
Problematic as Fanny apparently in that office before. So Fanny is causing a whole new bunch of law to have to be created in order to deal with this Fanny scandal. And so the judge is kind of asking them to brief him on this. All right. And I know the judge has done a ton of work on this. You can see all of his notes back there. He's writing stuff. He's looking stuff up on the computer, and he's trying to really determine what is the rule, what is the standard. And you heard a lot about this today, about the burden of proof. And we're talking about burden shifting. And this is going to be very important because the government is going to say that they don't have a burden to provide any evidence, right? If this is the defense motion to disqualify and dismiss, it's their motion. They have the burden. And this is like a weird little hearing because we're tucked in the middle of a criminal case and everything just got flipped over essentially for this one limited hearing. So now the prosecutors are like the defense, and they're going to say, we don't have to prove anything. Just like a defendant, right? A defendant in a criminal case can literally not testify or present one shred of evidence, not say anything. And if the government doesn't meet their case and prove their case beyond a reasonable doubt in a criminal matter, doesn't matter. Defendant walks free because we have the presumption of innocence on the defense. And now we're asking about that, right? Now we're asking, since this flipped over and since the defense is now acting as the prosecutors, right? They're going after Fanny. Fanny's team, I predict, they're going to come out and say they haven't met their burden, and the burden should probably be a lot higher than preponderance of the evidence. So the defense came out and they said, Your Honor, you don't need evidence beyond a reasonable doubt. Like, Fannie Willis is not on trial here. We don't have to convict her of perjury. We don't have to convict Nathan Wade of anything. All we have to do is show that they met the standard, not beyond a reasonable doubt, which is what the co-defendants in this case would have to be met with. And beyond a reasonable doubt, it's like 80%, right? You hear this in the movies all the time. If it's like 80% or more that a person is guilty or committed the conduct, they'll say they're guilty of the crime. But preponderance of the evidence is much, much lower. It's like 51%. So if it's more likely than not that Fannie and Wade did all the things that they just alleged, then the idea is they should be disqualified, right? Because it's a preponderance of the evidence standard. And the defense is saying, we've met our burden, okay? We've already put up enough evidence to meet that 51% threshold, and therefore it's a done deal. And I thought it was very good, right? The judge was poking holes in a lot of this, but the last attorney just came out and plugged them all up. And they did that largely, right? They came back out and they said, oh, you asked for a limiting principle. How about this? You asked for this. How about that? Is that Fannie? Did Fannie just enter the courtroom?
Yep.
I think Fannie's in the building, my friends. I think Fannie just walked in here. Oh my gosh.
Big
Is
Shark
she gonna
just
do
entered.
some closing arguments? Oh, okay. So Fannie is now in the room. We're going to do a quick refreshment break, my friends, and we're going to be back here in 1 minute. And I think it's going to be Fannie time. So I'll see you here in 1 minute. See ya.
All right. So this is going to get volatile. She's a proud Black woman. Cat just knocked over.
Oh, shit.
All right, my friends. I think we've got Fanny in the building. She looks like she's seated there in red. Oh, you know what they did?
Is that the same red dress?
They put a person in between Fanny and Willis. You see that? Fanny's like, I really want to sit next to you.
Or no?
But it'd be better looking if they put the white guy in between Fanny and Wade. See that? Fanny's not sitting too close. She's like, why don't you sit there? I'll sit over here. Better look, you know. You don't want them sitting too close. They might start making out in the courtroom, you know, and then they'd be caught for perjury again, for lying again, that their relationship ended. Hey, keep your hands above the table, Fanny. Keep your hands above the table. We can't see your hands, Nathan. You too. Keep your hands up there. All right. We should have the judge back any minute. And we're going to hear.
Yeah, what's the over under on when she's going to
again,
full
I
race
think that
start?
they're going to go back to materiality.
There we go.
Judge is back. All right.
Just sit.
All right. Please be seated. And here we go. We're going to hear from Adam. And Fanny Willis is in the courtroom, my friends, if you haven't seen it. Fanny Willis sitting right there, a nice distance between her and Nathan Wade, so no funny business accidentally happens there.
All right, we're back on the record.
What's up, Judge?
Stay ready.
Yes, Judge. I just am trying to get to where I can share my screen.
We need to add you as a host then. What's your profile name on the Zoom? Your screen name on the Zoom.
Adam, bottom.
All right, just making sure. Bear with us. Do you need it right away?
Does he have a PowerPoint?
No, I can start with that.
All right, floor is yours.
He has a PowerPoint presentation.
Good afternoon, Your Honor. Start with some of the things that were addressed over the last hour and a half. First, beginning with something Mr. Merchant referenced as it related to the comments that the state made in regards to the good faith basis in which was submitted to the court, in which defense counsel claimed
This is the guy that's been
the evidence
objecting
would show.
constantly.
And I would strongly bring to the court's attention that the claims that were made were material misrepresentations. And what I will what I will say to the court,
Oh my God.
and why I say that to the court is because the representations that were made by counsel was that Miss Daisha Young, Miss Sonia Allen, Mr. Dexter Bonds, Investigator Hill, Investigator Green, Investigator Ricks, all of these people would be called and Mr. Bradley would be able to impeach their knowledge by saying that he specifically
Look at Ashley.
in his presence or to him said that Miss Willis and Mr. Wade were in a romantic relationship and that Miss Willis and Mr. Wade were cohabitating, that they all, and I would submit to the court, we
Ridiculous.
didn't hear from any of those individuals.
She's not required
Mr.
to
Bradley
call them.
impeached no one. And I say no one because he did not impeach Mr. Wade. In order to properly impeach a witness, you have to confront the witness with the specific statements. Mr. Wade, and you can look back at the YouTube of the entire
We were here.
hearings of the last couple days, Mr. Wade wasn't once confronted with a statement that he claimed or said, or that is claimed that he said to Mr. Bradley.
Fanny moves one seat
The
over.
way you properly impeach somebody, you have to confront the witness. Here would be Mr. Wade.
She wanted off
And
camera.
once he makes a statement that you believe to be inconsistent, and you have a witness who can prove that inconsistency, that's when you call that witness.
Got reeks of soy boy.
And when Mr. Wade
What is he
was on
talking
the
about?
stand, not once was he asked, did you tell Mr. Bradley this in a confidential conversation in your conference room that was not covered under attorney-client privilege? That was not asked.
They don't
The
have to ask
specifics
your
of that
questions,
conversation
Adam.
was not asked.
They don't have to call
So any
all the witnesses
testimony that
either,
Mr.
Adam.
Bradley testified to is impermissible. It is improper impeachment because they did not confront Mr. Wade with it. So that's
Okay, so
would
he's
begin with the comments that
grasping
Mr.
at
Merchant made
technicalities, right?
about me referencing his wife as lying. I never called Miss Merchant a liar. I never used those words. I don't know why she made the material
It
misrepresentations.
wasn't.
It could be because Mr. Bradley lied to her. I don't know the reason. So, but I can submit to the court that those were material misrepresentations that were made to this court on the day a few Mondays ago.
Judge isn't going to buy
As
that.
everyone was arguing
No.
the motions to quash certain subpoenas.
Nice try.
I'd also bring to the court's attention that during that motion to quash subpoenas, certain subpoenas, Miss Yurdy's attorney appeared, Mr. Partridge, and he made very clear on that Zoom that Miss Yurdy had absolutely no knowledge of a romantic relationship and absolutely no knowledge of cohabitation.
But she did.
Those were the specific references that he made.
Okay.
So
He's trying
what
to
I
go
would
backwards, right?
submit to the court is those are considered adoptive omissions that his client has made based on the statements he made because of the representations she made to him. So, and I know that sounds convoluted.
It
But
does.
what I would say to the
Yes,
court
it
is, Miss Yurdy told Mr. Partridge because Mr. Partridge
Sounds
she
convoluted
had
because it
absolutely
makes
no information about a romantic relationship, and she had absolutely no information as in regards to.
So, but wait, are you making an argument I should make
I think
inferences
the-
based? Now, these would be attorney-client privileges or
the
communications
judges-
then. She's
Well-
communicating with Mr. Partridge about what her upcoming testimony is. That's why she's hired him. And you're telling me I should infer things based on her communications to him?
Absolutely, because they're not attorney-client communications anymore when he
This dude,
discloses them to the court and everybody else as they watch the Zoom and
he's trying to
attend
go
the hearing.
backwards.
The difference is there was no request to go in camera. There was no request to go or to have a private conversation with you as was done with Mr. Bradley. That would have been the proper procedure. So yes, I'm asking you to infer that 100%. I'm asking you to infer that her testimony was at best inconsistent. Because the testimony of Miss Yurdy, when she testified, was vague,
Want to see the
very little
pussy?
description when asked in a very leading manner. Is it true or do you know that Miss
This is my little guy.
Willis and Mr. Wade were in a relationship from 2019 into the time you were
so happy.
fired or excuse me, you were forced to
I'm so
resign
happy.
from the district attorney's office in
He's
March of
so happy.
2022. She said yes. And then further, when pressed by Mr. Sadow, he talks about why she believed they were in a relationship. And what was interesting from Miss Yurdy's testimony that they were pretty close friends up until she left the DA's office, that she
Right.
asserted to the court that on a yearly basis, Miss Willis said, I'm in a relationship with Mr. Wade in 2019. Oh, by the way, I want to tell you again in 2020, because we're in a new year, I'm still in a relationship with Mr. Wade. And again, in 2021, the assertion is Miss Willis then went back to Miss Yurdy and confirmed, hey, I just want to reconfirm me and Mr. Wade are still in a relationship.
I don't remember
It's
that
absurd.
testimony.
It's absolutely absurd. More importantly, when Mr. Sadow asked her about
She
why
observed
she believed
everything.
that they were in a romantic relationship based on her own
This
observations,
dude's grasping.
she said something. He actually asked her, did you see him kissing
This
or
guy's
hugging?
grasping
She said yes,
unbelievably.
but there was no description or qualification about when it occurred, what she actually saw, excuse me, was a
Solved.
kiss on the cheek, things of that nature.
She
So I would
said
ask
they were in a
you to,
relationship in 2019. She was very credible.
frame her testimony from that standpoint when you're addressing her credibility.
That was
As
not
the court is going to do with each and every witness that you heard during the testimony of
He
all the
he
witnesses
does.
in
This
during the
guy
hearing.
Let's see if he
guy
talks
sounds
about
like
the
Cleveland
device.
Brown from Family Guy.
Yeah, share your screen. Let's see what your little notes are. Pull your slides up. Come on. Oh, we got your slides. Nice, nice PowerPoints. Great from this prosecutor. Oh, good. Nice PowerPoints. Typical prosecutor background too. Yeah, real fancy. Nice job. All right, so pull it all up. I'm a big fan of PowerPoint, by the way. I happen to love PowerPoint, but prosecutors
Oh,
just
and it's
dorks.
gone.
All right, so pull it up. Let's see them. Hopefully they put it back on the screen. Can we see them? There we go. All right. Yeah, a lot of text. You know, they have to read it. Prosecutors are very good at reading things. So this is a whole new experience for him where he has to, you know, be on the defense side. It actually takes some creativity and some work. You have to be able to think on your feet. Prosecutors are used to
Now I
just
wanna
reading through the slides.
Talk a little bit about the standard and the burden here in
Paint
this
by number
instance
prosecutors.
as it relates to
That's all they can do.
defense counsel and the claims that they have made in the motion to disqualify. And as I was doing a whole lot of research, I came upon this law review article from
Law review article.
Cornell scholarship
Oh, gosh.
reading or publication.
Do we need to be here for this?
And they made very clear that courts have been relatively reluctant to exercise their power to disqualify prosecutors for any reason.
A law review article.
And
Great. Is that a case?
That goes along with the standard what state would submit to the court is that the defense has to show an actual conflict. And in this instance, they have to show the actual conflict would be that Miss Willis
No.
Received a financial benefit or
She did.
gain and did it based or got it
Stutters
based
the
upon
defense.
the outcome of the case. It doesn't make any sense. It
Not
makes
the
absolutely
outcome.
no sense.
She's prosecuting a case.
During the 3 days of the extensive testimony of all of the witnesses and the prolonged examinations of the witnesses by multiple defense counsel, they still got nowhere. We're in the same position we were in on Monday.
No, we're not.
The same assertions that were made on Monday have no answers today as we're before your honor.
We have 6 of them. That last
They were
attorney
not
just
able
articulated
to
them.
provide any evidence as to, or to the contrary of Miss Willis and Miss Wade's assertions of when they were.
Yeah.
began.
When's he going to pull up
You
a
literally
report by
just
Jen
talked
No
about
Psaki?
evidence
Robin
that
Yurdy.
contradicts that the relationship did not begin later than or around March of 2022, Your Honor.
Dude, you just mentioned
I
Robin.
further
like
submit to the
5
court
minutes
because
ago.
of this failure that their assertion or their request that one, the indictment be dismissed. There's absolutely no evidence that the defendants in this case, their due process rights have been harmed in absolutely any way. There was zero
case,
evidence.
The
Not
whole
a
case.
single shred of evidence was produced through any of the exhibits or the witness testimony showing how their constitutional rights, their due process rights were at all affected
They've been
by
charged
the
with crimes.
relationship that began in March of 2022
They've been
with
charged with
Miss
crimes and
Willis
arrested.
and Mr. Wade.
How's that?
And because of that, the motion to disqualify should be denied. And Miss Willis, as the district attorney of Fulton County, and Mr. Wade, as the special prosecutor assigned to this case, should be allowed to remain on this case and continue to prosecute the case to the end, Your Honor, until the trial is set by the court and is to begin. Now, the issues, obviously, you've heard a lot from defense counsel as to
He tried to talk
what
about
the
materiality.
issues
right?
are for you to,
It's pretty rough here.
I guess,
It's pretty rough.
determine. And here would be the state's contention is that
I wish we could
you
see the
must find that
judge.
there's an actual conflict if you
We have
were
6 of them,
or
yes.
are to come to the conclusion that you should disqualify Miss Willis and the district attorney's office. And looking at and
Yeah, I wish we could see the
Go
judge's
talk to
face
Fanny,
during
see what
this.
she has to say.
I think you're talking about, is this Ventura?
it's McGlynn v. State, McGlynn v. State, 342 Georgia
Okay, high
Appeal,
standard of proof. They want it
170.
closer to
it's
be
2017
beyond a reasonable
case.
doubt,
In
right?
that case, is it talks about the standard of proof that the defense or the burden that the defense must show and go to show an actual conflict is they say it's a high standard of proof, which is definitely not a preponderance of the evidence,
they
which
want
is
it
a much
higher.
lower burden
I think they meet
for
beyond a
any
reasonable
party who's
doubt.
trying
I
to
have no
meet
doubt.
that standard of preponderance. But it's clear that the standard is that is a high standard of proof for both when determining whether there's an actual conflict
I think
and when
that's
there's
been
forensic
met.
misconduct that is found, Your Honor.
Great.
And I want to go through some of the cases that defense counsel has
Skipping a lot of slides there,
referenced
Adam.
as they argued here today and in their filings. And bright line standard, or the standard and the grounds for which disqualification is appropriate for Your Honor to be determining in all of the cases as it relates to disqualifying the elected district attorney, is you either find there's a conflict of interest,
Got that? Yep.
or that there's been some sort of forensic misconduct.
Got that too.
Those
Thanks.
are, I guess, the two areas that Your Honor, that is in your purview when you are looking to resolve an issue regarding disqualification. Now, in a recent case, Levy State, which is 224 Georgia, and I'm sorry, Lexus 31. It's a February of 2024 case here out of our appellate courts. And in that case, Justice Pinson wrote that a trial court did not abuse its discretion by failing to disqualify an assistant district attorney absent an actual conflict of interest. And that is the case that was ruled on by the Georgia Court of Appeals about a month ago.
That's
Your
great.
Honor.
We have an actual conflict of interest. We have 6 of
Now,
them.
the cases in which defense counsel have relied on in their briefs and here today, I would submit to the court, the sites are misleading.
Wow.
Are inapplicable.
That's a very good
inapplicable,
slide. Very
and
good
some of
slide.
them
Wow.
actually support the state's position.
Glad he put it on there.
And what I would say to you is that the defendants, in many instances, combine language, the multiple cases,
This should be in the
and
notes section. So if you want to have better PowerPoints,
kind of
talk about that.
what I would say is
Don't put it
mistakes
on
the
the
law
slide.
as it relates to
Bullet
what
points.
the law or what is required in order for an elected district
Is he just
attorney,
reading his own
and their
PowerPoint?
office to be disqualified. And what I would submit to the court
Let's
is
go back to that. Show me how.
Perfect. Let's go, Judge. Yeah.
show you
explain-
how.
So I think the first one they cited was battle versus the state. Certainly a conflict of interest or the appearance of impropriety can be the grounds of disqualification.
Oh, his PowerPoint slides are going to get messed
Well-
up now. He got asked a question. Prosecutors aren't used to this. Go ahead.
And there are a number of these cases that
They're-
seem to exclusively rely on the appearance of impropriety.
Right. Well,
So
what I-
they acknowledge that there's some ambiguity here, that sometimes Whitworth gets cited to Ventura, and we've got this quote that comes up where it's just they only cite to an actual conflict
Uh-oh.
that must be involved. They acknowledge the ambiguity. You're saying there's no ambiguity whatsoever.
I am saying that, and why I am saying that, why I would submit that to the court is in all of those cases, they do reference the appearance of an impropriety, but they reference that because they all there's an actual conflict in each one of those cases.
So your position would be your review of the case law. There's never been an appellate opinion that relied only on an appearance of impropriety.
As it relates to a prosecutor or district attorney, yes, that is what I'm saying. What I would say is in those cases, they do reference the fact that there is an appearance of impropriety, but they reference that fact because when you have an actual conflict, there's always an appearance of impropriety. And those are what those cases stand for. And though I guess that is the main example of
He's saying there's no actual
what I
conflict.
reference as they kind of combine the language from separate and different cases and tell you that the standard is an appearance of impropriety. And I would submit to the court that is not the standard.
That's not what
And,
they're doing at all. They're showing the
In
cases.
my first reading, like Your Honor, I did notice that the cases each reference the appearance of impropriety, but also that appearance arose from the fact that the court found an actual conflict
Yeah.
in each one of those cases. So I won't belabor the point in going through all of the cases that the defense had cited, but what I would submit to the court and reading those cases is that I found that they kind of fell into 5 categories. That some that didn't concern disqualification at all, some that determined or that
We
were
can read
about.
it. We can read it.
I call it divided loyalty, which is a conflict that arises from representing becoming a prosecutor and then having represented the defendant prior to becoming a prosecutor, and then whether there's an actual personal interest in the outcome. And then others talk about whether the defendant was denied a fundamentally fair trial at the conclusion and of the case. after conviction.
And is this Calibri, the font? Is this Calibri?
And these are
I
some of the
think it is,
cases
isn't
that
it?
defense counsel had cited within
Very basic.
their brief that had
Very
absolutely no
basic to use the
application
default font
to
on your slides.
the issue that we're here before your honor today. The first, McIver v. State has nothing to do has nothing related to the disqualification of anyone.
And I think some of these are just relating to kind of aspiring for broad language about standards to prosecutors. So point taken there. But if they're more, all right, keep going.
All right, whatever. Keep going. I don't care. Okay.
So as it relates to one of the cases that was referenced here earlier and is also in some of the briefing by defense counsel is the Regested v. State, which is 287 Georgia 542, and all of the cases that fall under this what I would call category is about
What I would call
a
category.
attorney who formerly prosecuted a defendant in I guess the same type of case or the same case or similar charges, and that would be why the courts the courts found that disqualification would be necessary because of the relationship that existed between the former client and the now person who's being prosecuted, Your Honor.
All right.
The next series of slides just goes through what has been
Brutal.
addressed as it relates to the standard
This guy's burning.
that is required when
Burning
dealing
up.
with the issue of disqualification, and the state would contend and submit to the court that the defense must show an actual conflict in order to have the district attorney disqualified, and that actual conflict has a form of showing that Ms. Willis, in this instance, received a financial benefit or gain in relation to the outcome of the case.
If they
And like
dismiss
many of the
it,
cases
she can't
that
keep paying.
involve personal interest,
Wait.
Your Honor, it's all based on a contingency fee, where how much they're paid or a bonus,
All
for
right, so he's
example,
trying to distinguish some
is
other
dependent
cases.
upon the outcome of the case. That's how one is to show that there's a personal interest in the case. We have none of that here. And I would submit to the court, we have absolutely no evidence that Ms. Willis received any financial gain or benefit. The testimony was that Ms. Willis paid all of the money back in cash as related to the trips.
She's
And
not
it didn't
credible.
pay back in cash. It was
All right, let me explore this one a little bit.
Mhm.
So in addition to, you're saying it's only an actual conflict, are you also saying that it's only if a financial interest is affecting the final result, the outcome? That's the only one we should be worried about?
Not the initiations or the
Is it that the
continuation?
prosecution as a whole is what we should be looking at in terms of a stake? So what I'm thinking of, I'm just going to try and come up with some hypos here. What if ADAs are given a bonus for every motion to suppress they win, $1,000 per Fourth Amendment claim they win?
Yeah, what about
Well, now
that?
they've got officers is lying not to tell you about it because they want to win that motion to suppress. But maybe that doesn't affect the outcome because you can win a motion to suppress or lose it, and that doesn't decide whether it's going to be a guilty or not guilty verdict.
Great
But
question,
doesn't that
Judge.
affect the prosecution of the case, if not the outcome?
Yes, I would definitely agree that that would be an instance where disqualification would, I guess, be necessary and appropriate because
Well,
it's a situation that involves a contingency fee. And I would submit to the court that it actually does end up affecting.
It could, based on how important the motion to suppress is, right?
Right.
But if it's some immaterial,
An
I don't
indictment,
know.
like they
but
did with
I guess,
Nathan.
so you're saying it's maybe not so much just whether it's a guilty or not guilty dismissal, no process at the end of the day.
His arguments.
It is actually the conduct of the prosecution that should be
Yes.
looked at throughout the course of the
Oh,
prosecution.
sorry, Adam.
Correct, as it relates to how it affects the prosecution, which I would submit to the court
Yes.
ultimately is going to affect the end outcome of the case. If you have a contingency fee based on winning or how, if you win a motion to suppress
You
and
just agree with the defense.
if you win, you get, a bonus, as Your Honor referenced. I think that is ultimately going to affect the end outcome of the case.
So is
because,
an indictment.
as Your Honor just said, where an
Hello?
officer's lying or that where there isn't a good faith to go forward with that motion, the prosecutor would go for it with regardless.
Yes.
Because
An
of the
indictment
contingency
came.
fee, which not only affects the prosecution at that point of the proceedings, but ultimately is going to affect the entire case. Because if
Yeah.
they were to win a motion to suppress, or I guess the motion would be denied, and the evidence wasn't suppressed, knowing that they didn't have a good faith basis to go forward affects the ultimate outcome of the case.
So does an indictment.
So I
doesn't
think
it?
it's twofold,
Wow.
as Your Honor has referenced. I think it's at that part of the, I guess, the procedure of the proceedings would definitely qualify for a reason necessary to disqualify a prosecuting agency. But ultimately, that action during the procedure will lead to the ultimate outcome of the case.
Yeah. So will an
being
indictment.
hinging upon a contingency fee,
Thanks for agreeing with
like
the defense.
of the ones
Well done.
in the cases referenced by counsel and the state that are on the screen.
I think the judge just
So,
trapped him right there.
So getting into the language again, what you just had up there with greater amusements
Mhm.
and amusement sales. Greater amusements is one of those. You refer to the appearance of conflict as dicta. Why do you think that's dicta? I think the quote from that one is, it guarantees at least the appearance of a conflict of interest. Why is that dicta? It seems very central to the holding of the
Judge
case.
did his homework.
Because I don't disagree with Your Honor, but in that case, an actual conflict was found, and the appearance.
They didn't find that.
I would disagree with Your Honor. I would.
Bummer,
My
man.
reading of the case is that an
Read it
actual
again.
conflict was found, but because of that actual conflict, an appearance of impropriety was seen.
This guy drew the
and
short
that's,
straw, man.
That's the reference
out of Fulton County.
or why the state referenced that case in relation to the argument that an actual conflict is required.
Judge is like, I read a different case. Yeah. Strange. Okay.
Is that it? Oh no, we got more.
Series of cases.
Oh man,
Young,
this is rough.
that was referenced by defense counsel, as well as Nichols v. State.
He's just
are
slow
both
rolling the
instances
next
where
slides.
there's a personal interest in the case due to the situation and where at one point they were opposing parties. And of course, there's a personal interest or stake as it relates to prosecuting an opposing party in a civil claim,
Look at all
which
this
are what
text
both
on
of
this
those
slide.
cases reference, which shows that there's an actual conflict of interest that relates to the personal gain of the specific prosecuting agency.
And what do you make of Nichols' reference to, it's an older case. Sometimes the language can be what we're not accustomed to seeing, but there's, they
These are all
refer
copy
to the
and paste
metaphor
slang.
of Caesar's wife. And generally when there is a ethical standard, that's something that goes beyond just an
This is
actual
nuts.
conflict, right? Isn't the beyond reproach getting more into appearance world?
Judge knows the cases, man. The Georgia cases. Good.
Is it getting beyond?
No, isn't getting into the appearance aspect of things when we're talking about Caesar's wife.
But I think it goes beyond that based on the language of the holding in that case, where it literally says that the individual had a personal interest in obtaining a fee by forcing a settlement in the civil case and using the criminal case as leverage. So that's not an appearance of impropriety. That is an actual conflict of interest in which arises because of the individual's personal stake in the end outcome of the case, Your Honor. So that's how I would differentiate, I guess, the representations of defense counsel as it relates to the
Actual conflict, right? Isn't the beyond reproach getting more into appearance world? Crushing.
Is it getting beyond?
No, isn't getting into the appearance aspect of things when we're talking about Caesar's wife.
But I think it goes beyond that based on the language of the holding in that case, where it literally says that the individual had a personal interest in obtaining a fee by
It sounds
forcing a
like
settlement,
Cleveland.
in the civil case,
Family Guy.
using the criminal case as leverage. So that's not an appearance of impropriety. That is an actual conflict of interest in which arises because of the individual's personal stake in the end outcome of the case, Your Honor. So that's how I would
Watch a little bit of Joe
differentiate,
now.
I guess, the representations of defense counsel as it relates to the standard or the burden that must be shown, and why the state would submit to the court, and the most recent ruling out of the Georgia appellate courts that an
Child
actual
abduction?
conflict is required to be shown. So I'm going to skip through these series of slides because you've heard all about what works.
Because you're killing me. You're killing me with every case I bring up. I'm pointing out how wrong I am. So let me just skip through this.
Marshallville.
So I go back to
You're
what
just
we
gonna embarrass me
referenced
more on this.
earlier, and what's been referenced by all parties, that
Oh my
the
God.
grounds in which
He's
a
drowning.
district attorney can be disqualified is where a conflict of interest is found.
I'm going to
and,
rewatch this
whether
closing tomorrow night
forensic misconduct
because this
that
is
that is
terrible.
found. Those are the two grounds
I'm
are
rewatching this tomorrow night.
be, I
This
guess,
is terrible.
are within the purview of the court as it relates to the issues here. And again, I go back to the most recent case that was Justice Pinson wrote about, and that there must be, that by failing to disqualify the assistant district attorney absent an
interesting.
actual
Thank you,
conflict
Debbie.
of interest. I think the language there is very clear,
that.
and I think it's very controlling. And I think it's purposeful,
It's
I would submit to the
terrible.
court, because an actual conflict of interest is what is required.
Yeah, he
in
does have
order
a
for
better laugh.
district
Well, I haven't heard this guy
attorney,
laugh yet.
to be
This is
disqualified,
$250 an hour.
because the cases
This is what you get for
make
$250
very
an hour.
clear, and through the precedent relating to this issue, that a disqualification of a district attorney is the last, for a lack of better words, ditch effort that should, as it relates to the court in curing certain conflicts that may arise.
Okay.
I think the case law is very clear that every effort is supposed to be made instead of, or I guess in lieu of, disqualifying the district attorney unless an actual conflict of interest is what's found, Your Honor. And it can't be cured.
He's like, so maybe you can cure it some way? Maybe you can fix this problem some way? This guy is drowning.
So
Oh
what I
my
would reference to
God.
the court
This is hilarious.
as was brought up earlier in Lyons v. State 271, Georgia 639, a 1999 case where it talks about a theoretical or speculative conflict will not impugn a conviction, meaning that speculation, conjecture, things of that nature, assumptions are not enough for
It's not
anything to
speculation.
arise
We got
to an actual conflict. And
12,000
what I would
text
submit to the court as
messages.
well, that goes to
Speculation.
the fact that what has to be shown is an actual conflict. If it's speculation,
Is there any qualifier there though that's in a post-conviction context?
so
We're talking about, competent evidence, obviously in a pretrial phase here. I've wondered how much import to give that sentence when we're in a pretrial realm. That's
Maybe.
assessing whether to overturn a conviction.
This is
Usually
hurting her.
that's
This is hurting her.
kind of an
It's
entirely
really
different
insult.
standard where we assess as a totality. Was there a fair trial? Is there harmless error? I know there's no harmless error when it comes to disqualifications, but just a thought if you have any reactions.
well, I think
He is stuttering
what
his
Your
butt
Honor
off.
said is pretty on point in the sense that if it's
Pretty on
found
point?
that
So things can be kind of
the-
on
the
point.
trial court either applied the wrong standard or should have disqualified the district attorney, it leads to an automatic reversal, like you said, and it goes back to the trial court. And I think that is very enlightening in the sense that that's only done if an actual conflict is shown. And the fact that it can't just be theoretical, speculative, or assumptions that would lead to the appearance of impropriety, the appearance of a conflict that would lead to
I mean, I guess what I'm
just
getting at, I'm borrowing kind of from, as we've been doing in the other pretrial motions, special demurrers seem to get different treatment pretrial and post-trial. Post-trial, they get more of a pass unless you can show some issues. I'm wondering if that same applies here with disqualification.
Well, and I would,
But I don't have the answer to that.
well, what I would also say, and I don't remember the exact line, but I know there in Judge McBurney's order, he does address some of the concerns as it relates to the standard as it is applied post-conviction versus pretrial during pretrial issues. And what I would say to the court is that
So you're citing that in support? Because I didn't think the state was all that pleased with the analysis he applied.
well, what I'm citing,
Legal analysis, that is.
well, I'm citing what you specifically referenced as to the standard that is to be applied pretrial and post-trial, whether it makes a difference. And what I would say to the court is the answer is no, as it relates to the speculative nature of the allegations or the claims made by defense counsel as it relates to whether a conflict actually exists, Your Honor. Disqualification, that the standard is the same, whether it's post-conviction or pretrial. In Bloomfield v. Bornstein, which is 247 Georgia 406, it's a 1981 case. In that case, it says the appellees have not shown us a case where a per se rule was applied to disqualify an attorney on the basis of an appearance of impropriety alone. The Georgia cases cited by the appellee do not stand for the proposition that a trial judge is authorized in Georgia to disqualify an attorney solely on the basis of an appearance of propriety, which further goes to the state's submission to the court that the standard is that an actual conflict must be shown, and that conflict that arises shows that there's a personal stake of the district attorney as it relates to their personal financial gain that's being alleged. So in the case that's been referenced, all parties here today, Whitworth v. State 275 Georgia,
More slides.
Appeal 790 to 2005 case. In that case, it says Whitworth's complaints are largely based on speculation and conjecture.
He's pounding the
Applying
law.
any evidence standard to the record, it
Doesn't
is
have
clear
really
that the
good
trial
law,
court did not abuse
but his
its
facts
discretion
are
in denying
terrible.
Whitworth's motion to
So he's pounding
disqualify
the law, pounding the
more than
law,
based
pounding the
upon
law.
his
Doesn't have
personal
any
interest
facts. We'll see if
in
he
his
gets to some
conviction.
facts, if he applies any facts. to
Aren't we
the law.
past the speculation and conjecture aspect of this, though? I mean, the original and the core of the
Yeah.
financial allegation was that there is a relationship and that money has changed hands. There's maybe still an open question of where the ledger stands, but I think it was conceded that that balance could run in one way or in the district attorney's favor. Is that contested?
Yes. What's not contested is that a relationship did develop
Right.
between
And that purchases were made back and forth. That's the state's position.
that is the state's position, but they were made back and forth. The purchases were made back and forth,
Even
either
Stevens.
to equal the money that was spent by one party or the other. And if that wasn't done, cash was exchanged in order to equal the cost paid by either one of the parties.
Even
Right.
Stevens.
But that's a facted issue, whether it was, split even, or whether it goes a little bit one way or another, or whether it's all the way $10,000 one way or another. That's a fact and issue as a result of the hearing, but it's no longer just the theory that money changed hand is no longer speculation or conjecture.
Well, I agree that money actually changed hands is not speculation and conjecture, but whether that money that changed hands had any financial benefit or gain to the district attorney, that is all speculation and conjecture. I would submit to the court. Absolutely all speculation and conjecture to harass and honestly embarrass the district attorney based on some of the questions that were asked that had absolutely nothing to do with the proceedings that we were here. For example, the lien on her alleged house, that was highly irrelevant, had nothing to do with the proceedings and the exchange of money between the district attorney and Mr. Wade. The point of that line of questioning was to, again, embarrass and harass the district attorney in a way that was very public, and in a way that was to impugn her character as it relates to that line of questioning in front of the court, in front of anyone watching the proceedings as it unfolded.
Yeah, I don't think the
And
judge
the language
is buying this
in
at all.
Whitworth, I would again submit to the court, requires that an actual conflict must be shown, which is why the reference to speculation and conjecture is a reference, because speculation and conjecture leads to or equals an appearance of impropriety, not necessarily an actual conflict, which I submit to the court is what is required based on the case law.
So hopefully we get to some actual facts of this case. He's just telling us about the case law, but we want to see what some of the weakness is in the actual evidence that was here, right? Pound the law if you have it, pound the facts if you have it, or pound the table if you
Georgia
don't.
Appeal 606.
He's just
The
all law.
1989 case. And it says, while the prosecuting officers should see that no unfair advantage is taken of the accused, yet he is not a judicial officer. Those who are required to exercise judicial functions in the case are the judge and the jury. The public prosecutor is necessarily a partisan in the case. If we were compelled to proceed with the same circumspection as the judge and jury, there would be an end to the conviction of criminals, which goes to the premise that the appearance of impropriety is to apply to judges, not prosecutors. Because if that standard was to be applied in the manner in which the Sutherland case is referencing, then there would never be criminal prosecution.
We're talking
because
about an
it's
affair.
always going to appear biased as it relates to getting justice for the victims or righting the wrong as it relates to the crime.
So you're holding prosecutors to too high of a standard here. Fanny's
been indicted or accused of.
If she has to be above board, then she'll have some bias and she can't charge anybody. Come on. This is not what, this is so far astray, I think, from the actual facts of this case that it's just, it doesn't even apply. Fast forward through that one.
I want
Here
to
we
move
go.
into
Evidence.
I guess
Finally.
the evidence
Thanks.
that
Thanks
Your
for getting
Honor
here.
saw and heard during
Oh gosh.
the last couple of days, 3 total days of testimony.
Look at number
As
5.
it relates to the witness. The
Look at
witnesses
number 5.
you heard from Ms. Yurdy, who the state would contend is a disgruntled former employee.
I think
You
Robin
heard from
Yurdy told
Terrence
the truth.
Bradley, also someone who is a disgruntled former partner. The text messages in the state's opinion show that he is vengeful. You heard from his own testimony here, sitting before the court, that all he did was speculate, and any information that he had and garnered
After
and
he
then
got that
passed on
game
to
phone
Ms.
call.
Merchant was mere speculation. I believe he said that over and over again when asked if he had personal knowledge. My recollection is around 15 times he said he had absolutely no personal knowledge of a romantic relationship between the DA and Mr. Wade. You also heard from the special prosecutor, Mr. Wade, a former judge. You heard from the 80th governor of the state of Georgia,
Who provided
Roy
nothing.
Barnes.
Who provided
You
nothing.
heard from the first female elected district attorney of Fulton County.
She's black too,
And you
by
heard
the
from
way.
her father, who was a 40-plus year practicing
First black
attorney,
female. Why'd you leave
in
that out?
good standing when he left the practice of law. And what I would submit to the court is that Miss
Here's the Yurdy
Yurdy's,
slide.
testimony was nothing more than inconsistent at best, based on what I referenced to the court earlier as it relates to the representations that were made by her counsel prior to.
Are those in evidence? Would his responses during a motion to quash, which weren't subject to cross-examination by defense attorneys, weren't even part of the evidentiary record of the hearing? Again, I'm just kind of puzzled by that. You didn't ask the question of Ms. Yurdy, what did you tell your attorney before coming here? And then we could have dealt with privilege issues and
Yeah.
whatever else.
Why are you trying to shove evidence in here, Adam?
I would agree with the court. It's not an evidence, but it was
So why are you talking about
a
it?
statement by an officer of this court to the court during a hearing related to her testimony and how we would proceed with her testimony in this hearing. But it's clear that what was
trying.
represented as to
Poor
why
guy.
she
I almost feel bad
would
for him.
not have, I guess, be an appropriate person to testify was that she had absolutely no knowledge of the romantic relationship. That was the basis of why her counsel was saying that she shouldn't have to testify. That
So
she
then,
shouldn't be
so then
compelled by
under
the
that
court.
theory, if accepted, where did the incentive arise between Monday and Thursday for her to completely change things around?
Where did the incentive
So
arise?
she was fighting so hard to avoid if we're going down that road you propose, she was fighting to have not to come in here and testify at all. And then she comes in here and testifies. Why would she have testified the way she did if she didn't want to testify so strongly? If we're going down this road of trying to just gauge her
Good
interests
question.
and
That's not on
these
the
kind of
slide.
things, I don't know if
He's
I'm
like-
quite following that theory.
Not on the
And
slide.
I can appreciate that, but I would say the reason she didn't want to testify, I would submit to the court, is because this is an incredibly public forum where she would have to testify against a former friend and a former boss.
Yeah.
And I
And
think
probably face a
the
lot of the same
change,
pressure in the
I
Terrence
wouldn't
Bradley
qualify it as
cases.
as an incentive. What I would qualify is ultimately, when she was forced to
Motive.
testify, right, a motive and a bias as to why she testified in the manner in which she did. When asked by Ms. Merchant as to the reasons for her leaving, she kind of danced around the issue. And then as Ms. Cross, whether she resigned or forced to leave, she was fired, she came out and said she was given the choice, you can either resign, but either way you're leaving. You're fired, or you can resign in a manner in which, you know, she wouldn't be officially fired.
Because Fanny's
You know,
corrupt.
and when she's trying to get future employment and things of that nature. So I would submit to the court that there's absolutely no incentive. An incentive is not why Miss Yurdy's testimony changed, or the state would contend her testimony changed, but it was the reason she testified the way she did was because of her bias towards the DA, which gave her motive to what the state would contend is be less than honest before the court. And I would.
But if we're going to draw inferences based on her fighting the subpoena, why would she have fought it if she had such a bias and wanted to say these untruths?
Because she didn't want to come on national television and have to be exposed to the things that
You
He
guys.
can't. He can't even find an argument.
Yeah, you guys calling.
I don't know
witnesses,
anybody who
assaulters
wants
or
to testify before a court in a normal trial, a normal proceeding, but one of what I would qualify as in this high profile of nature, where everybody would be able to watch and learn at what she has to say as it unfolds in the courtroom.
the
And
truth.
I'd further submit to the court, there is reference to she left the DA's office in the text message that were submitted in, I believe, what is it, Defense Exhibit 39, that it's because she released confidential information in the DA's office, from the DA's office, that led to her firing.
So
That she
that's
wasn't.
wild.
And I know I'm just because it's more conversational, which I appreciate. I know I might be getting you off script, so I don't want to
Oh, he's
use up
away
all
off
your time
script,
if you need
yeah.
to get through some other things.
Next, Terrence Bradley, and I believe the one thing that the state and defense counsel can agree on, that he was less than honest at times during the proceeding and during his testimony.
Everyone calls him a liar.
When Mr. Sadow, why he was fired, he basically chalked it up to a dispute between partners in a business. But when pressed by Ms. Cross, it was clear that that wasn't the reason. And what I would submit to the court, what has been referenced by defense counsel,
Terrence is getting destroyed,
as
man. Look at this. Look at this slide.
baffling as
Less
to why
text,
the state
better
would go
slide.
into such a topic area. The state, as all counsel has when appearing before the court, has a duty of candor. And when Miss Cross
Yeah.
knew she was going to have to cross Mr. Bradley, she knew he lied. And she had a duty of candor to the court
She was still
in the
objecting to
state's
protect
opinion
him.
to expose that.
Wild.
More importantly, it goes to his credibility and the statements that had been represented by defense counsel that he allegedly had made in the past. So it was important to bring that to the court's attention, because when a witness is testifying, the court
Oh, talking big
is
crap. Big crap.
assessing their credibility and determine to whether to believe the veracity of the statements made by the witness or not. So that is
This guy was trying to
that is
sanction
the
Ashley
most
Merchant.
important factor
Okay.
when
They were
determining
objecting to
whether somebody
protect
is
Terrence
telling
Bradley.
the truth
Talk
or-
about
or
duty of
lie.
candor.
Furthermore, he
They were protecting
reluctantly,
him on the stand the whole
when
time.
pressed, finally admitted that he paid off the assault victim. You know, eventually it started with an escrow account and led to he did pay off.
Yeah, and
the-
you and
the
Anna
victim
were
in that
jumping up.
case.
Objection, objection, objection. Right
He
before
testified
that.
over a span of 3 days, and like I referenced to the court, he must have said 15 times that he had no personal firsthand knowledge
Right, and that
as
was
it
not
relates
credible.
to the relationship
Everyone knows that
between
was a
Ms.
lie.
Willis and Mr. Wade. More importantly,
It's funny he will
when
reference that.
pressed by counsel,
You just said he was not
he
credible.
could not
You just
pinpoint
said he was a liar.
a time in which he knew that the relationship occurred.
And then you reference
there were
his
many
statements as being
instances in which he
credible.
described that very well could have fallen within
Good job.
the time frame that
Good
was
job.
testified and by both Ms. Willis and Mr. Wade as it relates to the relationship beginning or transitioning into dating in March of 2022 and into the end of the relationship in August or the summer of 2023.
Great. So now,
And as I
now we should
referenced
believe him
to
on
the
that?
court, the statements that Mr. Bradley made, the state would contend are inadmissible hearsay as it relates to the statements that he was pressed and asked about what Mr. Wade told him, because Mr. Wade was never confronted with those statements.
So
And in order for impeachment to be proper, he must be confronted with the specific statements
they want all the
that are alleged to have
attorney-client
been made
privilege
in
stuff
order to
also
impeach
thrown
him.
out on hearsay. He just
Again,
skipped over that.
Mr. Bradley had every motive to lie. I believe the text messages are kind of
Thriving law
clear,
practice.
are very clear as it relates to his disdain towards Mr. Wade, which due to the fact that, you know, he was expelled or exiled from a thriving law practice. And it was clear that the practice and Mr. Wade sided with the alleged sexual assault victim, which is clear he assaulted her due to the fact that he paid her off. And as I referenced earlier, you know, Ms. Merchant represented to the court that Mr. Bradley had personal firsthand knowledge, basically of it all, of everything, and that he would be able to basically be an impeaching machine. I think Your Honor referenced him as the star witness when you were addressing the claims that were made by Ms. Cross in relation
That
to
was in his text,
Ms.
Adam.
Merchant's representations to the court.
Before you
And,
guys flipped
what
him.
I would submit to the court is that all Mr. Bradley's representations as it relates to whether or when the relationship between Ms. Willis and Mr. Wade began,
Did he really
and,
put the words lies, lies, lies? on
whether
his
they
slides?
cohabitated, because that was a promise that was also made that he would be able to impeach the investigators as it relates to cohabitation was mere
Didn't call them.
speculation, gossip.
Didn't call them.
Um,
They don't have to call all
and
your
this
witnesses.
is, Your
The
Honor,
question I got, and we can
Yeah.
correct this while we're all here together, is that Mr. Bradley directly overheard a statement from each of these individuals that they could be impeached with. Ms. Merchant, is that accurate?
Directly overheard. Which ones are we talking about specifically?
Well, essentially, that kind of seemed to be all of them. You had said Allen, Bond, Young, and then the investigators, Hill, Green, and Ricks, could all be directly impeached by statements overheard by Mr. Bradley.
Yes.
If she would have called them.
in reference to your question, the unequivocal answer was yes. And when Your Honor is looking through the text messages, I would submit to the court that the text messages don't even say or indicate what was represented to the court in relation to the good faith basis for this motion to disqualify as it relates to the testimony of and the ability to impeach witnesses through Mr. Bradley.
She didn't call them. They got what they
What's
needed from
been
Nathan
referenced,
Wade.
by all counsel is Mr. Bradley's assertion of absolutely as it relates to whether the relationship existed prior to Mr. Wade's hiring.
He didn't
And
play
the
that video
question
clip
in
on that
itself
last slide.
involves speculation because it asks, do you think it started before she hired him? And he says, absolutely. He doesn't say he knows. He doesn't provide any context as to how he knows. And in these text messages and through his testimony with the court, the source of his information
Hi, Greg.
That was on January
was
5th
unclear.
this year.
What I would say to the court. As to a lot of things, other than the
Well, 'cause
one
he was
talking
conversation
about this
that
guy's
allegedly
speech.
occurred between Mr. Wade and Mr. Bradley. And I would submit to the court that that conversation never occurred. That would be the state's contention. And how do we know that? We know that because that conversation was not confronted, or Mr. Wade was not confronted with that conversation. And that is evidence circumstantially, and I'd even say direct, as to that conversation not existing. Because based on the representation made by defense counsel, it would be clear that that would be a conversation that would have been relayed to, because it wasn't privileged, as Your Honor found, that would have been relayed to Ms. Merchant. And if that conversation happened you better believe that would have been a conversation that defense counsel would have confronted Mr. Wade with and against. And the reason they didn't do that was because it didn't exist. You heard from Mr. John C. Floyd III, the
Fanny's
district attorney's
daddy.
father. As Your Honor heard, he was a well-respected member of the legal community for over 40 years. But the importance of his testimony was to provide the court with corroboration as it relates to
He was totally not credible
the
because
years
he
leading up
listened to
to
Fannie
the
Willis's
relationship
testimony.
that
He even admitted that.
transitioned
Well, I listened
into
on talk
dating
radio.
between the district attorney and
So
Mr.
he
Wade.
came in and
What he
just
testified
supported
to is that
Fannie
he moved
completely.
into her South Fulton home in 2019. The evidence of his moving into that home at that time was his Georgia driver's license, official government document. He further testified that not only did that just Miss Willis and himself live at the South Fulton home, but that he often would see on numerous occasions the significant other of Miss Willis that was not Mr. Wade. He referenced that that person had a nickname of Deuce, and
DJ
that
Deuce
he kept a
in the
lot of his
house.
belongings in the garage of Miss Willis. He specifically said he kept a lot of his disc jockey.
That's why they
equipment,
needed
as
the
he-
condo,
as
so they had a little
is how
bang
he
house,
referred to
right?
it,
Because Daddy didn't want
when
Nathan
before the
Wade
court.
indicting his
He
daughter.
made very
the
clear
bedroom.
that he had never seen Mr. Wade at the South that is owned by Miss Willis. He made clear that he
Totally
lived
uncredible.
in that
Guy,
home with
watch the
Miss
slot,
Willis
watch the
and
whole
Miss Willis alone,
presentation. Next
other
slide.
than her two daughters who would occasionally visit that home until
Hey, Harry.
after February of 2021. But what precipitated the soon move of Miss Willis to what I would reference as
It is a little
safe
bit
houses,
boring, but
for
it's
her
also
protection
very
was,
interesting. This guy,
a protest that occurred before her home in February of 2021.
the other
He
attorneys
then
were much
expressed to the
more
court
easier to
that,
listen to.
Ms. Willis moved in the spring of 2021.
This guy is just
and that due to
droning.
these threats that were taken
What does
very
this have to
seriously,
do with
he had only
anything?
seen his
Yeah.
child 13 times. He
That's as true as
said,
indicting Nathan.
in reference to the questions by defense counsel that were in a,
This is where we learned about cash. Remember Fanny's daddy said, hey,
and
you know,
I'm just going to
we
be
keep cash.
straight up with the court. They were trying to make
You better be
Ms.
straight
Willis
up
a
with the
liar.
court.
She is a
How
liar.
I would submit to the court, in the sense that she testified that she was concerned for her safety and her family's safety, which included her father and her daughters, and that Mr. Floyd remaining in that home kind of rebutted all of that, made it so it wasn't true. But he testified that he stayed in the home because it was a home that she had put her blood, sweat, and tears in and was able to buy, and that he stayed in the home because there was constant officer presence. He told the court that he bought extra security equipment. He even went as far to tell the court that
Got you,
he
Farlap.
slept in different rooms on different nights because he felt his safety was in such a concern.
They banned
So
your
I would
live.
submit to the
Why?
court that line of questioning was done in an attempt to discredit Ms.
What were you
Willis,
playing
but
copyright material?
would be this how the state would characterize
It's
it.
mostly irrelevant. You know,
Then
it's,
he testified about
she's a
the
liar
first
about
time
that
he
too.
did
A lot of
with
times,
Mr.
if you
Wade,
just
which is
stop
in,
playing it,
2023,
they'll let your live come
here,
back up again.
at the district attorney's office.
where they were
And,
sleeping with each
he
other
talked
is
about
kind
Just
of
strike.
irrelevant. They made it a little bit more
how he
secretive
kept
by
cash
having this
in his
separate
home
bang session
and
house
why Miss
down in
Willis
South Fulton.
kept cash in his home. And what I would, what the court should take
And he's the
note of
cash
is
guy, right?
the state didn't ask Mr. Floyd about the cash in his home. That came out through the cross-examination of defense counsel. So
Jesus.
there was I guess, the implication
Yeah, this guy is definitely.
that Mr.
So they're
Floyd
saying
only
it's no
did
big
so
deal that
due
they
through his preparation with the
only
state,
use cash and there's no record
hearing
of
and seeing
an exchange of
news
money.
articles and clips related to the
There's no
testimony
issue with
that
that.
had occurred
Although
prior
there,
to
there
him.
would be if
But I would submit to the court
they're
that it's
prosecuting a
telling
drug
that
dealer.
that information came out through questions that were asked by defense counsel, which gives credibility to the statements that were made. And he further explained as to why he taught his daughter to keep cash
Yeah, black people
in the
keep
home
cash.
as
White
it relates
people
to
don't
financial
understand.
independence and
Remember.
having a safety net.
We
It was
played a
further
Friends
testified
video
that
and he
he had
reported it.
multiple safes and that he gave Miss Willis
Did you get a
his
strike?
first lockbox, or her first
Wow.
Or a
What a
warning?
beautiful moment
for
between a father and a daughter.
situations
You got
as she
banned.
described when she was testifying. And what I want to make clear is during Ms. Willis's testimony, it was pressed about the cash and where she kept it and did it follow her?
'Cause it was
where
ridiculous,
She laid
yeah.
her head and things of that nature, trying to further discredit the practice that she had as it
Exactly,
relates to keeping
Farlout.
cash in her home and why she had the ability to pay cash to Mr. Wade and other people and for other situations. And what the court should take note of is that there was no evidence that controverted that at all. Where was the evidence that controverted Miss Willis's claim and
2
practice
strikes?
of keeping cash in her home?
You
There was
can't
none.
disprove that. That's what's
In
so
fact,
ridiculous about
The
it.
only evidence
It's
was
cash.
it was substantiated through the testimony of her father,
He
Mr. Floyd.
He wasn't present to those transactions. He just says, I taught my daughter to keep cash. He didn't know anything
Furthermore,
about the actual
you heard
transactions.
from former Governor Roy
Again,
Barnes.
Roy Barnes is
and,
not
His
relevant.
testimony was significant and important
No, it wasn't.
because
It
what I
absolutely
would-
was not.
how I would phrase it.
He was
Your
on
Oh,
there
good.
for like 5
Well,
minutes.
Let me on this point,
Mhm.
and I think you might have had a more recent opportunity to review his testimony than I have.
Mhm.
You say on the slide that she
Thanks,
was the
Farlout.
first
I haven't
choice
even
to
looked at it.
lead the
I'm not going to
prosecution.
open it up while I'm streaming.
Was that
my
actually his
TV.
testimony, or was his testimony that he was asked to come aboard? Did he use the words that he was asked to lead?
Yes, it would be that's my recollection that he was asked to lead the prosecution. He was asked to.
Yeah, I'm going to change that
take
link.
or he was asked
I
to fill the
probably just
position
remove
that
that
Mr.
link and
Wade
just
is currently
give it
in,
out
which is
whenever
the lead
fucking folks
prosecutor.
want to jump
It was
in. I
said in
think
that way
because
as
it's
well
part of
as
my
it
link
relates to the
tree,
testimony of Mr. Barnes.
I'm getting a lot
So
of
I think it would
weirdos
be very
popping in
clear.
there. That's why I keep
My
asking.
recollection is that he said lead, but what I can submit to the court that I know he also said that he was asked to fill the Wade is currently filling for the state of Georgia.
So
which
because
is the
At
lead
that
went to
prosecutor.
time,
this guy
as
first.
special grand jury prosecutor, right?
Yeah, the special, I guess, yeah, as the special prosecutor lead the investigation, which led to the ultimate prosecution that we're here before Your Honor.
So because she checked
today.
with the governor.
He also indicated that the reason he turned that job down was because it didn't pay enough.
She could
He said
then
he had
hire her
mouths to
boyfriend
feed,
afterwards.
at his law firm, and that he also didn't want to live the rest of his life with bodyguards because he had lived that for the years in which he was the governor of Georgia. Furthermore, he confirmed the qualifications of Mr. Wade, which I still find it quite interesting and confusing as to attacking Mr. Wade's qualifications, in that it's almost as if Mr. Roman's counsel is asking that the state put a prosecutor on the case that she sees to be more qualified to attempt to convict her client.
That's not the argument.
It's an interesting.
It shows there's a
ar-
conflict. She hired
argument,
her
and it's one
boyfriend who's
that
not qualified.
makes
Why?
no sense.
Because she's her boyfriend.
Furthermore, if you were to believe the claims and allegations as it relates to Ms. Willis' personal stake in the prosecution, the receiving of financial benefits and gains, then you'd have to believe that she was also dating Roy Barnes, the former governor, and Gabe Banks,
Was
in
she?
addition to Mr. Wade. If she has this grand plan scheme in order to profit off of the prosecution of this case,
What a
because that's
dumb
what they're
argument.
saying.
Oh my
Or
God.
they're saying that she
doesn't have to sleep with all of them.
prophetically was able to know that Mr. Barnes and Mr. Banks would turn down so she could then hire Mr. Wade.
Or
It's
she wanted to
ridiculous.
look like
It's absurd.
she talked to
and
other people.
It's desperate. It's a desperate attempt to
Wow.
remove a prosecutor
Good reading.
from a case
Good reading there.
for
done.
absolutely no reason, Your Honor,
You see that?
other than harassment
We got capitalized again, but we didn't have bolded or underlined.
and embarrassment. This slide, and we've been through a lot of the testimony.
And I should be clear there, it was not introduced in evidence that Mr. Banks turned her down, right? How's that part of the record?
Well, I'd ask the court to take judicial notices, has been asked repeatedly.
Unless the district attorney had testified to that. I don't recall offhand.
I will be frank with the court. I don't recall if Ms. Willis testified to that exact fact, but I know that Mr. Banks represented that to the court during Monday's hearing. as it relates to the allegations that were made. I understand Your Honor's position as it
I'm just
relates.
trying to make
that.
sure we know exactly what is in the evidence and is not, but
Well-
regardless, I think your point is made.
I think it's an evidence of the record as it relates to, I guess, the issues that led up to the actual hearing of this case. So I understand Your Honor's position, but it did come out or during a proceeding that was prior to the actual hearing. This slide is just a
The
chart showing kind of the
consistencies.
testimony of both
Wade and
the
Willis are
district
both
attorney,
honest
Ms. Willis and Mr. Wade,
because their
as it relates to
testimonies
how
are
they
in
met,
sync.
how
Charts are
or
good
when
tools for this.
Mr. Wade became the special prosecutor, when their relationship evolved into a romantic one, talking about the trips in which they took after their relationship evolved into one
Yeah, they
that
got their stories
became
straight and
romantic,
they both lied
and
together.
when
Great.
it ended.
Thanks for showing
And
us.
what, again, I would submit to the court is that those facts were consistent. And the only person who contradicted that when the relationship started was Miss Yurdy. And what I would bring to the court's attention is that it was represented to the court that Miss Yurdy was a witness
Ozzie and
other than
Harriet?
Mr. Bradley, who could bring to the forefront this issue of cohabitation. And when pressed and when asked about it, Miss Yurdy had absolutely no information as it relates to this alleged cohabitation. It was false. She said she had no information. She was asked about trips. She said she had no information
4
about the trips.
trips.
Yet,
Cruise 1, Aruba,
she's such a good
Cruise
friend
2,
that
Belize,
Ms. Willis
Napa.
confirmed each year that Mr. Wade and her continue to be in a relationship in 2020, 2021, until their relationship ended due to her forced resignation and
Good luck with that, Gregory.
splintering of their friendship, Your Honor. I guess several exhibits obviously were tendered in. Most of them were exhibits that came from the sealed divorce of
So you shouldn't be
Mr.
allowed to
Wade
look at
and
those.
Miss Jocelyn Wade, contracts for legal services, trip itineraries, and the text messages. And I would specifically reference prior to today, the only text messages that were before Your Honor were defense exhibits 26 and 27, which it's the assertion of defense counsel that what those show is
There's
that
the
Mr.
wine
Bradley
guy, the affidavit
was
from the
in
wine guy at the
informa- or
bottom.
had information as it relates to the relationship starting prior to March of 2022, and that's just false. Those text messages do not contain that. It does not pinpoint, just as Mr. Bradley couldn't, when the relationship actually started. And furthermore, you have the testimony and the evidence of the text messages that it was mere speculation.
Are we
If
only
you,
48
as Your
minutes
Honor
into this
reviews
thing?
the full chain of text messages, it is clearly Ms.
Jesus,
Merchant
this
and Mr.
guy.
Bradley going through
I'm sure
what
the
I
judge's
can
head is
describe
nodding
as
right
nothing else
now.
other than a mere fishing expedition
Oh,
between the
gosh.
two of them at first, because
That's
it's asked
prosecutors.
about
That's what they
certain
all
members
say.
of the DA's office who would have information as it relates just specifically for one, Miss Young. It is asked whether she would have information, and he had no idea. He said he assumed, he was speculating. And that is the same as each person that was subpoenaed
he
in
was not
reference
credible.
in the text messages.
You got what? What's
All of that was speculation. And you know it was speculation because not a single one of them testified. That's telling. Because if it wasn't mere speculation, if it wasn't mere gossip, and if it wasn't mere conjecture, each one of those people who were subpoenaed would have been called to testify, like
Somebody
District
owes
Attorney
the
Willis
rights to
was,
They
that.
all locked
like
their stories
Mr.
up,
Wade was,
and we got what we needed
in
out
order
of
to be
Terrence
confronted.
and everyone else we had.
and then impeached by Mr. Bradley.
So you didn't call enough evidence. If you would have called more, then you
You've
could have
heard
proven your case.
obviously
but you
about
didn't.
the phone records, and I have a maybe because whether it comes into the purview of Your Honor as it relates to the determination Your Honor is to make.
That's weird
as it
that it's
relates
going to
to,
take that
the
long.
disqualification of the district
Usually it's
attorney.
within
You also have the affidavit
an hour or so that they
from
get
the
back to you
employee
on
who
that.
worked at the winery, who confirmed that Miss Willis did in fact
The wine
pay
guy.
In cash.
We have one
ups
example
to,
of a
more than
$400 cash
$400.
payment from
And
some random dude.
I understand that this is part of the proffer of the state, but it's important because that is a witness who the state didn't go find.
Is he going to go the whole 90 minutes?
To CNN in order to confirm what Miss Willis testified to, further giving her statements, credibility, and credence before the court. You heard about.
Well, before we move on from that one, other than the foundational concerns, would you have a response to the proffer of the cell phone records?
I have, I'll get to that now. I was going to get to it later, but I have several foundational concerns as it relates to the cell phone records. I don't think I've ever, as Mr. Sadow's motion makes very clear, the state uses cell phone records routinely. And I would agree with that. We use them
All the time.
routinely, but we use them with an expert, and they're always challenged.
Right. So, like I said, in the interest of time, setting aside the foundational concerns.
Oh, I thought you were asking about
No,
them.
no, no. Focusing on the substance of them, assuming it would be admissible in the guise that he's proffered. What's maybe you have that further up, but what's the reaction to that?
So what I would say initially is that due to the fact that they were analyzed by someone who was a non-expert, the analyzation of those cell phone records were not properly peer reviewed. They were not, it's clear from
I understand that, but you gotta prove it's a false claim.
Software you guys use
that are used
or
to
sucks.
check,
use.
It's better
the
just
use
to
of
take
which
it
kind of
down.
data is being used. Reference to the
You're not going to win a fight with
I believe
YouTube.
it's September 10th and
I'll tell you
11th
that.
and
You guys
November
didn't refute
29th and
that.
30th. The affidavit that is used to say that Mr. Wade remains at Miss Willis's or in the area.
The only
of
time I've ever
Again,
won
during
a
the
copyright
hearing, we
claim is when I
addressed,
went to the
for
person doing
the,
the claim
Yurdi condo never
and
came
asked
out.
him
It
to
was just
remove
that it
the
was
claim, and I
Hapeville
promised
condo.
to
The
cut out
actual
that
phone number
portion
for
of my
Mr. Wade
stream.
was never established. And the documents that
not a
were
criminal
provided
Only
to the
time
state
I've won a
as-
claim.
that were
That
certified
person's not willing to
business
do
records
it,
did not have
you're gonna
a
lose.
subscriber page. So we have no idea that the
99.9%
number
of the
belongs
time.
to Mr. Wade. Now I understand Your Honor wants to look past the foundational issues, and I can appreciate that. But
Later,
the
Harry.
Trying to get it
foundational,
dismissed on a
stuff's
technicality. He
very
sounds like a
important as it
defense
relates to
attorney a
the
little bit
admissibility
right
of the
now.
record.
Thanks for
No doubt
dropping
about
in.
that. But if somewhere how they were able to survive those foundational concerns, do you have any reaction?
Yes, I do, and I will skip forward so I don't.
Yeah, go back to your script.
Screenshot of what?
Let's see.
Them giving you
There
permission?
you go. Go to the cell
So-
phone records. Wade's handset was
What's
never in South
interesting
Fulton.
is that the records that were provided were they start in January of 2021 and they go, I believe it's to November 30th, I think is what the of 2021, the
Yep,
span
we're
of the
missing
records.
December, yep.
And you heard from all of the witnesses, including Miss Yurdi, that Miss Willis did not move into the Hateville address until April of 2021. That was the testimony from all of the witnesses, April of 2021, and that she lived in her South Fulton home from when she met Mr. Wade in October of 2019 up until when she had to move. And the assertion by defense counsel is that Mr. Wade and Miss Willis began a relationship right after they met in October of 2019. What's interesting and what's telling is that Mr. Wade's handset doesn't once appear in anywhere near the area of her South Fulton home, but they're dating, but they're in a serious relationship. And if you were to believe what the defense counsel says, that they have been in a relationship from October of 2019 up until she moves in April of 2021. So, a year and a half or so, but he never once enters the area of her home. But they want you to believe that that's a lie, which is why counsel for defense continued to press District Attorney Willis and Mr. Wade as to whether he had ever been to that South Fulton home. Well, this corroborates that was not a lie.
And you're sure that
he had never been
this
to that
ex-friend
home,
of yours is the one who put in the
more than
claim, or is it
suspect if
the
you've been in a
copyright holders of
relationship,
the
as they
Ozzie and
claim,
Harriet?
for all this time, but never once went to the
Because
house.
even though he may have
Went to
gotten
her
away with
bang house.
publishing
I
that,
think that's telling.
Went to
What I
Robin
would also
Yurdi's
bring to the
condo.
court's attention in the state's initial
it
review. of
depends
the
on who's
records,
making the
that,
claim.
from January of 2021 to March of 2021, those times when Miss Willis did not live again at the Hateville address, she didn't move there until April of 2021, that his handset appears in that area 23 times.
Sure.
Why
How
she's
do
not
you
living there.
reconcile that with this testimony that was alluded to, I think, by opposing counsel, the reasons he gave for being in the area?
Well,
Yeah,
would those
I
line
agree
up
for
to
that.
23 times?
You got to prove.
At the Porsche
I think,
experience,
Tough.
that,
Tough.
Well,
I think
Tough
we have too
argument.
many reasons for being
Restaurants?
there, right?
what's he going there for then?
Well, I think that's the point. I would say yes, that is the point. he referenced that that's an area that it was not uncommon for him to be in. And clearly that is the case because Miss Willis didn't live in that area. So again, it's further corroboration as to what Mr. Wade indicated to the court. And when
So you'd have
I
to
guess
believe
after
that-
Miss Willis moved into the condo in April of 2021, they appeared 35 times. Now, I want to make clear to the court,
So why?
both
Why?
Miss Willis and Mr. Wade never denied.
Why
that
would
he'd
somebody
been to the
purporting to
condo
be your
before.
friend give you permission to do
The
that?
specific
and then do
testimony that
that,
was
though?
elicited by Miss Willis and Mr. Wade was that he had never laid his head.
That's the next
was
question.
the
Why?
direct
Why
quote,
would he do that to you?
At that condo, which
Never
these
laid my
records don't
head.
prove that he laid his head anywhere.
Whoa.
If you were to believe the analysis, or if you were to
I didn't sleep over.
if you
I
were to
never
give
laid my
credence
head.
to what the non-expert says as it relates to
So they must have been indicting each
Mr.
other
Wade's
on the couch,
handset
you know, or on the
in
kitchen
September
table.
and November for the 3 to 4 hours that the phone is alleged to have remained. That doesn't disprove anything that was testified by both Mr. Wade and District Attorney Willis. It was that he visited there.
My next
The
thing is
specific
that
hours
how
of
is that
his-
person
of their visit
able to
was not
claim that this
something
Ozzy and Harriet
was pursued
video
during the questioning
that
of
he
both,
actually has rights
parties.
to it
So
to copyright you?
what I would also submit to the court is that if you look at the days as it relates to in September,
Yeah, wish you knew.
the use, I guess the type of information that is used to make the plots for the longitude and latitude of the handset is data records. It's not voice records. It's not
Duplicate
SMS or
entry.
Have
text
you asked them
messages.
why?
It's data records. And
Or are they
it
not
is not
responding to you now?
uncommon for an expert to testify as it relates specifically to AT&T records that actual data record is unreliable as it relates to the location of the
Yeah, look at
handset
my
due
disclaimer
to
or look
the
at my
type of
description.
information that
It
is,
goes
that
on
it's
every
data,
one of my
it's not the
videos
voice. And yes,
when I'm playing other
that's which
content.
I know, Your Honor, as it's been referenced, was a prosecutor not only here in this county, but for the federal government, where this kind of information is commonly used. So in the comments that were made by the court, it was clear that you understood and understand the use of cell phone records as it relates to put somebody in an area, and again, not in a specific location. I'd also bring to the court's attention as it relates to the expert that was hired by
It's a good riddance.
Mr. Sadow, is that not once does it reference the fact that AT&T
Pretty much that's
records
my
commonly
standard.
have duplicate and
There's just I have that on
within the call
almost
detail records.
all streams. I try
That
to
is something
anyway.
that is commonly seen.
Make sure that's in the
and that
description
is-
because you never
that is
know
something that is
you might
seen
come across somebody's.
in these records, and that is something that
stuff.
leads to.
I mean, it's not going to
the
completely protect
incorrect
you, but
number
it may
of
help.
times that it's been alleged that Ms. Willis and Mr. Wade were in communication through text and voicemail. And I'd also
I've
submit
also
to the
added
court
little
that
intros,
that
even
number
though
doesn't prove anything. Again, doesn't prove that anybody's in a
it's funny
relationship.
too. Even though
It proves that they were in communication with each other.
About
the
And
NEFFEX
case.
music that I
I
use for
think
my
Your Honor
intro
can
and the
use
9
outro
o'clock at
your own
night.
life
are
experience
copyright
as it
free.
relates
He
to
can.
people you work
YouTube's
with, or
algorithm will
friends, that you are close with.
tag that
Yeah,
and the number
automatically
of
as
times that
copyrighted,
you,
but
Did you
then
ever
make
tell your
an
calls
hour later
to
it'll
colleagues
say
that
to
got home safe,
any of those
baby?
people.
permanent
I can
See you at
license
the office
because
submit to the
tomorrow.
court that
it's copyright free.
I
At 4 in
have
the
a
morning?
friend who I have
No.
been friends with for 15 years, and she worked
Yeah.
in the office previously.
Yeah,
with
you, I
me.
mean,
And
I
it
copied
based
mine
our
from somebody
professional
else's page,
relationship
and
and our personal relationship.
it's
the
it's
friendship that
legit
we had,
disclaimer. I mean, just you can just
had
or
and still
or
have,
do that,
that
yeah,
we talk
for sure.
30 times a day.
Fair
Whoa.
use
So
disclaimers,
And that doesn't
and
mean we're in a
it'll
relationship.
give you the whole
So
text.
the assertion that
What's your
the
wife
number
say
of
about that?
times that Miss Willis and Mr. Wade have spoken to each other, whether it's through text
You
message
indict your
or
colleagues too?
phone, has no validity
At 4 in the morning, 30
as it
times a
relates
day?
to them being in a relationship. What I would submit to
I
the
don't know what's
court
going
is
on there in
that
Fulton.
what was shown through all of the evidence was that there's been a true cost to Miss Willis as it relates to her life, that she had additional expenses that she had to endure
No worries, Greg.
because
safe
of
house.
her position, in
It's
the
a
sense
bang
that she
house, is what it
told the
was.
court that she had a mortgage, but
No
on
worries.
top of that mortgage,
My
that
gosh.
in a house she didn't live in anymore, she had to
Racism
pay
and sexism
for a
right
safe
here.
house, that her home was vandalized, and there were racial epithets and
Yes, we
sexual
know.
bigotry that were spray
Yes, we
painted
know.
onto her
Bigots
house.
everywhere. I know.
The concern of her safety and her life is something that was testified to, and the fact that this job has led to the isolation and separation of her from her family and friends, which was given credence and were provided by her father, Mr. Floyd, that he had only seen his daughter 13 times since all of these instances occurred. The full nature of the statements and the falsehoods that, for example, in these text messages that were purposefully leaked to the media as it relates to Miss Willis's daughter, subjecting her position in school, that she flunked out of college, which isn't true.
Okay.
Which in fact she has
How
graduated
about
from. at
Fanny
HBCU.
calling every co-defendant
But what
a
been leaked to the
racist
media is the fact
and
that she
being opposed by God? How about that?
flunked out of school, and someone other than her father
Yeah.
moved her, which again, the validity of which was never shown.
Yeah.
And all the while, Ms. Willis, facing these costs, has been able to continue to do the work unrelated to this case, which is shown in the fact that Atlanta's murder rate and violent crime rates have decreased while she has been in office. What was shown through the testimony of all of the witnesses and through the evidence that Your Honor heard was that there wasn't an actual conflict, that the defense failed to provide any sort of actual conflict in relation to Ms. Wade's
We got another note coming up
relationship
here.
that
Fanny
transpired
didn't deliver that note.
from the relationship between her and Mr. Wade, and that there was absolutely no evidence of a financial benefit that she gained as it relates to of the case. The corroboration of all of that is the things that Your Honor is very much aware that she could have, I guess, financially benefited from stretching out the case, for lack of better words, by the grand jury, or the special grand jury recommended that 39 individuals be indicted, but through her sifting through the special grand jury a report and all of the evidence with the
They
team
could have
that
prosecuted
indicted
more
the case,
people and ripped
they
off
only
more money.
went with 19 of the defendants, which had she gone with all 39, there's there based on the defense counsel's assertions, would have given her the opportunity to certainly
make more money,
find these financial gains that are claimed through the allegations of defense counsel.
Yeah, so Fanny realized that Nathan couldn't handle 39.
More importantly,
he can handle 19.
Why would Ms. Willis repeatedly ask this court to set a trial date as soon as possible if her motive in prosecuting this case was to continue to financially gain as alleged
What happened?
from the prosecution of this case? From the prosecution of this case.
What's going on?
Which there's been absolutely no
corrupt,
evidence of.
100%.
The evidence was
You're
she
not
stayed
like
at the
just a little
DoubleTree
bit
in
correct.
Napa, a DoubleTree.
What a ridiculous argument.
I don't know that to be a lavish hotel. Most people, when they go to Napa, if they want to lavishly experience Napa, stay at the Ritz-Carlton, the Four Seasons, things of that nature, not a DoubleTree. So the allegations and assertions that Miss Willis was living the lifestyle of the rich and the famous is a joke. Absolute joke.
She was on like 4 cruises in like 5
As it relates
months.
to what you heard,
4
and
trips.
the secondary issue is the forensic misconduct. And
This
for
poor
lack of
guy.
better
When's
words,
the last time he's been on vacation?
what it has
In
to be
Fanny's
shown is that
office,
the
right?
statements that were made by here, Miss Willis, related to the prosecution of the case and ultimately the guilt or innocence of the defendants. And we have none of those statements. There's been no evidence. Nothing has been provided to Your Honor as it relates to Miss Willis's specific statements made about any of the defendants and in relation to the guilt or innocence of any of the defendants. I forget which defense counsel referenced the fact that she said she had a 95% conviction rate. Well, what Miss Willis's job instill confidence in the community as to how well she is doing as it relates to her constitutional duties. And that was exactly what was done when she referenced that she
Yeah,
had a
double trees are
95%
nice, aren't they
conviction
nice?
rate from the previous year that she was serving as the district attorney. More importantly, it's been the allegations about race and religion being imputed in her speech, and that those comments were directed at the defendants at this table. And if you
They
listen
were.
to the speech, those comments are directed at two elected or political officials.
No, they're
I
not.
believe it was Marjorie Taylor Greene
No, it's not.
and
You guys are ridiculous.
Miss Bridget Thorne, who is a member of the Fulton County Board of Commissioners here. She specifically used their names. I don't know that they, and my knowledge is they're not supposed to be sitting at the table, and I haven't seen them in my work as it relates to this case, Your Honor. So those allegations that Miss Willis committed forensic misconduct are, again, there's no validity to them. There's no evidence of them as it relates to any of those comments, which this is an issue that Judge McBurney has previously ruled on when these same allegations were alleged as it relates to extrajudicial statements made by Ms. Willis. And it involved a statement that the words fake electors were said by Ms. Willis. And he found that there was absolutely no conduct that was impermissible as it relates to forensic misconduct.
All right. I think we've got like 24 minutes left of this dude. And he's just walking us through the
And,
slides, fast forwarding now a
I
little
guess to
bit.
drive home the point.
You've already done that.
No
We got
point
it.
in any of
got
the
it.
statements that were made and that are alleged here as it relates to the speech that she made at the church.
Look
At
at that
no point
statement.
did she mention the guilt
They are
or
Shit.
responding to comments made
There's no
by
precedent for
Marjorie
this.
Taylor Greene
You say
and Bridget
hello.
Thorne to other political officials, therefore making her comments not even
It's never
close
been
in the
happened.
realm
Never
of any
happened
sort of
before.
forensic misconduct. What I find interesting is that defense counsel wants to make these allegations that Ms. Willis committed this forensic misconduct by the statements that she made in this as two
Here we go.
unrelated.
Fannie was
distinct
bad,
public
but the
officials,
government, but the defense
criticized
is even
the job that
worse.
she was doing. And,
The defense is not a
I find
prosecutor
that
who swears an oath
obviously,
and gets a badge
interesting in the
like the
sense that
prosecutor does.
we've had video proffers released to the media by defense counsel, emails between counsel released to the media by defense counsel.
Yeah, good.
Statements have
Good.
been
So some
made
transparency.
by
I'm glad we
defense
got those
counsel
text messages.
in relation to this case. We had the unredacted version of the cell phone records of Mr. Wade released to the media by defense counsel with his private and personal information, causing the threat of harm to both Ms. Willis and Mr. Wade to increase. The most recent instance was the text messages that Your Honor hadn't ruled on their admissibility prior to their release. And it was made clear during
public
the
record.
hearings that the ability to get those, the full chain was something that they were unable to do. But they figured a way, and the minute they figured a way, they released it, the information to the media simultaneously with turning it over to the state.
Yeah, shout out to
the
Megan
court.
Kelly and Phil Holloway on that one. Shout out to Phil Holloway.
For all the reasons obviously stated before Your Honor, that this motion should be denied because the legal requirements that are required in order for the district attorney to be disqualified have not been satisfied. The defendants have failed to raise any issue legally or factually to satisfy the legal standard for disqualification. They must show an actual conflict. They've been unable to show that the prosecution of this case was at all a result of political bias, which has been accused or accusations have been made, as well as demonstrated that the prosecution of this case was motivated by any means
irrelevant,
or any way because of malicious prosecution. And they haven't been able to prove that this case was one of selective prosecution for political benefit or gain. All allegations that have been made during the course of different hearings and the procedures as it relates to this case. What I would leave the court with,
Thank you.
and how
God.
they
Jesus.
started
Finally.
the argument, is that courts have been generally unreceptive if not hostile, to attempts to disqualify prosecutors
This is true.
based on pervasive and institutional conflicts,
I think this
which
is
makes
true.
clear that the burden, that the standard is very, very high that must be met in order for an elected district attorney to be disqualified.
Yeah,
And
and
that
Fanny
burden,
just
that
pole vaulted over it.
actual conflict has
It's a
not
high
been shown.
burden. She just
And
pole vaulted.
more importantly,
Fanny,
in conjunction with
right
that,
over
there's
it.
been
Nathan Wade right
absolutely
behind her.
no evidence that the district attorney has benefited financially at all, but benefited financially
Four
in conjunction
trips.
with any outcome, whether it be now or ultimately as it relates to the prosecution of this case. And because of all those reasons, Your Honor, we respectfully request you deny defense counsel's motion to disqualify the elected district attorney, Ms. Fannie Willis.
Oh gosh, Fanny's now getting up, moving out of his
Thank you,
seat,
Mr. Body.
and Fanny's leaving the courtroom. Fanny is exiting the courtroom with her entourage.
That's what it says. Mr. Cromwell. I'll even, oh, you, okay, handing it over. Understood.
All right,
Mr.
get
Sadow,
those
all yours.
disgusting PowerPoints out of here. Trump's attorney, Steve Sadow's back up for some rebuttal.
I'm going to do
minutes.
rebuttal, specific rebuttal. One, the state somehow makes an argument that we should have asked Mr. Wade questions about his relationship and communication with Mr. Bradley when they objected over and over and over. Its counsel objected over and over and over, claiming that everything that Bradley was told by Wade was attorney-client privilege.
Exactly.
Your Honor made determinations thereafter
That it was
to
not.
Bradley. We didn't get the opportunity to call Mr. Wade back to the stand. So to claim that you can't impeach him because you didn't ask him when they objected to us asking him is obviously a false position to take.
Thank you.
As disingenuous as
Yep.
it can be.
Yep.
Now, if the court wants to open it up, we'll be more than happy to call Mr. Wade back to the stand.
Happy
But
to.
as the record stands, there could be no confrontation of Mr. Wade when both his counsel and the state are arguing that it shouldn't be done.
And covering up for what they know is going to be
Second.
perjury, which was so offensive about that.
Let's
Well
use
done,
a little
Steve.
common sense here.
Please.
Forensic misconduct received about 2 minutes worth of discussion. The rest of it is all on conflict. Forensic misconduct dealing with the way the state wants you to have it is if you don't accuse someone or you don't say that someone's guilty.
Yeah, assuming you can impugn someone's character to the degree that constitutes forensic misconduct. Why is that
I'm sorry,
the
say
case
that.
here? Assuming you can impugn someone's character to the degree that it constitutes forensic misconduct. The state's primary position was that they weren't talking about you at the church.
Right. And if you go listen to it and watch it, it starts off by saying, why does Commissioner Bridget Thorne and so many others, and then it refers to they attack him for being black. They attack him, not anyone else, just they attack the black man.
Yeah.
They're not talking about Miss Thorne or Marjorie Taylor Greene. They're talking about us.
Filing
And
a
you know
motion.
how everybody knows that? Because not a single story from the media reported anything other than Fannie Willis accused the defense and defendants of being racist.
Clearly.
Now, here's the common sense part of this. If you follow the state's position on forensic misconduct, Fannie Willis could all day long talk about race. She could say the defendants, I'm not saying they're guilty or not guilty, but they're racist.
Yeah.
They're racist. They're racist. And according to the state's position on forensic misconduct,
That's
that
allowed.
wouldn't be a problem.
Totally fine.
Obviously, that makes no sense whatsoever.
Their
The issue
standard is
here
stupid.
that we've dealt with on forensic misconduct, it's not simply the church speech. It's why she did it, how she did it, calculated, and all the other things that we talked about with the testimony of Wade. And let's go to the relationship issues and the cell phones briefly. No one knew that there was a relationship between Wade and Willis, according to Wade and Willis.
Right.
Not a soul was ever told that they were dating or that there was an intimate relationship, ever. They concealed it from all parties, from Daddy. Daddy didn't even know they had a relationship. To suggest that somehow in the beginning of 2021, January to whatever it was into April, that they couldn't have met in Hapeville. They didn't meet anywhere that would allow the public to see them. That's the reason why
They had a bang house.
they were meeting at Yertes,
Bang
because
house.
no one else was ever there. Remember the testimony? Who else was there besides Mr. Wade and Miss Willis? Both of them agreed. No one ever went there except them. They didn't go to where Daddy was in
No, they
Miss
didn't.
Willis's house because Daddy was there and Daddy would know. No other prosecutors knew. No one knows except who? The one person that knew was Bradley and Yerty. Yerty was best friend at that time of Miss Willis, and Bradley was the partner of Wade. Now,
Good stuff, Steve. Thanks for showing us how to speak like you
the
got a
only
pair.
way that Wade can walk, I'm sorry, the only way that Bradley can walk away from I have very little time, so I'll skip that. Let's go to something. Motive. That's an issue. Whose motive in this case is the strongest? Fonnie Willis,
Of course it is.
Nathan Wade.
Cover it up.
Because if they testify truthfully on every point, what happens if the relationship started before November 1st? They get disqualified.
Yep.
Who has the best motive of anyone to lie? They do. Who has the most at stake to lie? They do. Who wants to stay on this case for whatever the financial reason may be?
You're such a dick. You're such an asshole.
And
Oh, thank you, Mr. Sada.
Thank you, Mr. Steve Sadow, Trump's attorney. And I think we're done.
All right. Thank you, everybody.
All right, you're back, guys.
Ruling.
You'll let them outside.
I think has been very much made clear by the argument and the made today is that there are several legal issues to sort through,
Yeah.
several factual determinations that I have
Yeah.
to make. And those aren't ones I can make at this moment. And so I will be taking the time to make sure that I give this case the full consideration it's due. I hope to have an answer for everyone within the next 2 weeks.
2 weeks.
Until that point, if there are any other issues that come up, council can reach out
File your motions.
and we'll have an order posted on the docket. Thank you all. We're off the record.
All rise. Thanks, Judge. Oh, okay. We're going to debrief, my friends.
Wow.
And we're going to hear from you. So Fanny, as you know,
Thank you, sir.
it's Friday. She's probably already pounding that Grey Goose out in her office. Nathan Wade's going to go join her right now. Going to go fire back some shots. All right, please be seated. Judge is out of there. All right, let's see if we can percolate on any interactions that are happening back there. Okay, so Merchant and Merchant. Nathan Wade got a scratch on the nose. He's going over to co-counsel, getting some files. You got to get your files before you leave. So he's helping her grab some files. Let's see. Oh, let me move myself out of the way so you can see that. All right. All right. So Adam Abate has his backpack. Good. All right. And the courtroom's clearing out, my friends. So. All right. Let's debrief, shall we? We'll keep this open in the background. Let's do a little bit of a debrief. So today was a very interesting day. And I think, is that the judge again? Is he talking? No, I think that's someone else. That's probably Steve Sadow. Looks like Steve Sadow is back here. All right. So, my friends, the big takeaways. Now, this was closing arguments on the evidentiary hearing. And just as a quick recap, Fanny is on the defensive here. And the defendants who have been charged with crimes, they are the people who are acting as though they are the prosecutors for this very limited hearing. It's their motion, meaning the defendant's motion, to disqualify and to dismiss. And a big part of today's closing arguments was really about two things. One is about the legal standard. Okay, what in Georgia is the law? We've never had a Fanny situation like this before historically in Georgia. And so they don't have case law on this. They don't really know. And we spent a lot of time going through the cases to say, this is what the standard should be. So whenever Judge McAfee comes back out and issues a ruling, he's going to define that for us. He's going to say, this is the standard for disqualification. This is the standard for dismissal. Ashley Merchant's talking to the clerk, the court reporter, rather. And so we're going to see that. We're going to see what the standard is. In order to be disqualified, you have to do this, right? Just like in the law. In order to get a DUI, you got to be above 0.08 in some situations. It can also be impaired to the slightest degree, but you get it, right? What's the standard that you have to cross? That's number one. And that standard is going to have some elements to it, right? It's going to be defined. It's going to have some rules, materiality maybe in there. We don't know. Judge McAfee's really going to have to create this, sounds like, on his own. He'll be able to pull from some prior cases, but he's going to have to articulate what the standard is, and we'll see what it looks like. So we'll have those elements. And then once we get those elements, a little subcomponent to that is going to be what is the evidentiary standard. Okay, so once we know like relationship, benefit, materiality, maybe a threshold of $100 or more, whatever he comes up with, then we'll ask ourselves, what is the burden of proof? What is the evidentiary burden
sabotaging my new employees
to those elements, right? So he'll define the
Oh, I'm
elements
so pissed
for
right now.
disqualification and dismissal, and then he'll tell us that the burden, in order to show that there was a relationship or that there was a material benefit or something, he will come back out, and the Zoom screen just ended for us. But then they'll come back out and they'll tell us what has to be met. So in other words, in criminal law, you often hear that you got to be proven guilty beyond a reasonable doubt. And that's like 80% or more. If you have any doubt that's based in reason about a person's innocence or guilt or the elements of the crime, you got to find them not guilty. So that's a pretty high standard, right? And this is a criminal case, but this hearing is not a criminal hearing. This hearing is an evidentiary hearing, and it talks about disqualification. So the beyond a reasonable doubt standard that would apply to the co-defendants, to Trump and the rest of the co-defendants, that's not going to be the standard we're talking about, presumably. It'll be a much lower standard. So are Fannie and Wade disqualified? What standard applies? Probably won't be beyond a reasonable doubt, but maybe it's a little higher than preponderance of the evidence, which is like 51%. If it's more likely than not, they'll find that you did it. So think of that standard. That's mostly a civil traffic violation is typically a preponderance of the evidence standard. So if there was enough evidence to hit those elements, let's just call them relationship, benefit, and materiality, then what evidentiary standard applies in order to cross that threshold? If it's a high standard like the government wants, they want it to be very high. And they want the elements to be about an actual conflict. They don't want it to be about an appearance of a conflict. Those are different elements, right? One's stricter than the other. And so if the judge comes back out and he says, yeah, you know what, it is an actual conflict, then what is the standard that applies to that one? And is it going to be beyond a reasonable doubt? I would say probably not. Is it going to be above preponderance of the evidence? Maybe. Clear and convincing evidence? Maybe. The judge will have to come to that determination, but it's going to depend on appearance of impropriety or not. Now, the other component to all of this is the burden of proof. So a lot of different, complex legal topics there, but burden of proof is who has the burden. And in this case, it is the defense motion. So in theory, right, they've got to bring the evidence, the factual evidence, in order to make their claim. And what we're talking about in a lot of this is burden shifting. So the defense is saying, well, we've already made our case. Okay, we've already shown that there's some lies here and there's evidence of that. And so the government should now have the burden, right? The burden shifts from the defense because it's their motion. It shifts over to the government, and then the government has the burden of refuting that. Or they have or maybe they have the burden in the first place, right? We're trying to decide who gets to go, who gets to present the evidence that is going to be consequential in the outcome of this evidentiary hearing. But as we thought, the judge is going to retire. The judge is going to give this a lot of consideration and think through it. There was a lot of great testimony today. I think that the defense really did a nice job, and they have a nice benefit of having a whole slew of people there who can kind of plug the holes. So right at the beginning, we saw that there were some questions that were being lobbed at Mr. Merchant from the judge, and he was kind of trying to poke holes in it. And it reminded me almost of Supreme Court arguments or of an appellate court arguments where they interrupt you in closing and ask you about questions on the law, because that's what it was. The judge doesn't know what the law is. It's not clear cut either way. He's going to be making this up because it's going to be a case of first impression in here, especially in Georgia, especially with Fannie Willis being extra Fannie. It's like nobody's ever seen this before. So he's going to have to come up with a new standard, new elements, and then make these determinations. But he was poking holes. I thought Mr. Merchant did a great job. I really like how he came out and called the state, defended his wife's honor, called them out, said, you know, they have been reprehensible from the very beginning. They came in demanding sanctions, calling us untruthful and all those things. And obviously that's not what happened here. We got evidence that came out, and a lot of it supports the defense arguments. Steve Saydow was great. I love how methodical he is. He just comes out, walks us through basically the elements, and he gave us some very good background on the ethical rules that they have on the books for lawyers, right? Lawyers have higher standards of care, a higher duty of care, right? Like if there's a doctor who's operating on you, you expect that that doctor is going to provide higher care than someone who is a non-doctor, right? A non-doctor who's cutting your leg off is probably going to have a different duty or have a different idea of a duty, or we'd have a different expectation of that dude's duty than an officer who's a surgeon or a medical person who's a surgeon, right? Different duties, different standards of care because of your expertise. It's reasonable to ascribe a higher standard, higher expectations to the surgeon. Same thing here in this case, right? These are lawyers, and not just any lawyers. It's Nathan Wade, it's Fannie Willis. These are the two highest power attorneys apparently in Fulton County, maybe Georgia, and they should know better than to lie on their interrogatories, to lie on their disclosure forms, and to lie in their affidavits to the court. And that causes specific ethical problems and violations of the rules that you then say are evidence of the misconduct. And this was the forensic misconduct that then is parlayed into the underlying claim. In other words, all of that was done, all of those lies were done to cover up their original misdeeds. Like getting in trouble when you're a kid, mom says, okay, I know you did it. You're in trouble, but if you just tell me the truth, things will be a little bit better for you. We all know that standard. It's a pretty good one. We all make mistakes. That's fine. But if you come clean about it and don't double down, then usually you're shown a little bit of grace. And I think that's how it should be, because we're all human. But that's not what happened here, right? They covered up. They had people making phone calls to get rid of witnesses, and they lied in their documents, Nathan specifically, to hide all this materiality from his wife. And so it's reprehensible behavior, and they continue to lie, and it's an ethical problem. And I think Steve Saydow did a very nice job in calling all of that out. So there was a lot more that went on, my friends. We had a lot of details about the affidavits. Robin Yurdy came up. The government, I thought Adam Abate was the person who apparently drew the short end of the stick, and they just kind of gave him some slides, or he went up there. Fannie was like right behind him, like with a cattle prod. She's like, if you screw this up, we're going to indict you next. What do you think about that there, Adam? He's like sweating, flowing through his PowerPoint slides. It was a rough presentation. I'm glad he finished up early and didn't use the full time, because our ears were starting to bleed and it was painful. So in short, I think that what they were doing was a little bit of pounding the law, right? They don't have good facts.
Yeah, it was real bad.
A little bit on the back end of his presentation,
real bad,
about some of the evidentiary stuff. He spent a lot of time on kind of irrelevant witnesses, I thought, like the governor, who was not really that meaningful. Fannie's daddy, we had a whole big slide on that, but the rest of it was about the law. And even his interpretation of the law, I don't think the judge was very keen on, because he had read all the cases. He'd already seen it all. And every time he brought something up, he had some questions about it. He said, well, maybe my interpretation is going to now be what I know about the cases and my interpretation of it. So, all that being said, from here, we've been covering this at length, and we're grateful to have everybody joining us. We're covering all the Trump litigation, by the way, all of the J6 case activity, Florida case. Alvin Bragg is starting up in 3 weeks. We're going to be covering that trial at length here. That's going to be the next criminal trial for Trump. That's going to be a big one. And so thanks for subscribing, my friends, wherever it is you're joining us. Very grateful to have you, because this is a big deal. And what we're asking the judge to do is a big deal. And I can't understate that enough. I mean, what we've seen here from Fannie Willis is disgusting. As a licensed attorney, it makes my skin crawl to think that prosecutors are openly doing this. And then when they get busted on it, then they lie about getting busted. It's constant dishonesty. And I've already known, I got my own opinions about prosecutors, but what we've seen out of Fulton County has been at a whole different level. Now, that being said, disqualifying the elected DA is a big deal. It's a big deal, especially on this case of national importance. So We got some questions about what's going to be happening in the court of public opinion in addition to the court of law. We have all seen the court of law. We all know Terrence Bradley. We can judge his credibility.
I'll be all right.
You might have difference of opinions on that one, but I think it's been pretty clear that him, Nathan Wade, and Fannie Willis have been dishonest and lied in their documents. To me, automatic, right? If I'm a judge, you lied to me.
Yeah, they're gonna use
opportunity
whatever
to
they
correct
can. They're gonna
this,
make it as
You're
political
bringing dishonor not
as they
only to
can,
Fulton
even though
County,
that's
not
exactly
only
what they've done.
to the DA's office,
I
but
agree.
into my courtroom personally. And I've got an obligation to make sure that this courtroom is sanctified against all people.
Just about
who
every
come in
other
here and
county
try to
outside of
dishonor
Fulton
and
is
lies on it. Now,
more
if
red.
McAfee does disqualify her, and there's some sort of a finding of dishonesty.
Maybe
Some
whatever
time ago,
county
right, great
Augusta's in
questions
might
have
be
come
a
up
bit
here.
blue, but
Will this have impact on other Fulton County
that's a
cases?
big military
And of course, my
post
answer
there
was
too,
very
though. So
clearly, it's always, well, it depends. What is the judge going to do? If the judge says, yeah, Fannie is a corrupt liar through and through, every defense attorney in Fulton County in Georgia is going to be doing backflips on that one and saying, oh, perfect. Because now we're going to make different arguments to our judge, right? So the public policy is going to counsel strongly against the judge, disqualifying Fannie and calling her a liar, because every defense attorney, it's going to be like Pandora's box just opens. Everyone is going to go hog wild in Fulton County, and they are going to want to get their cases dismissed. So the whole county is going to be in disarray if she gets disqualified. And if the case gets dismissed, there'll be political consequences for this too. And so one other idea is that Fulton and Georgia, they've been coming up. And to my knowledge, I'm not positive on the dates, but to my knowledge, both Fannie and Judge McAfee are up for re-election. And there will be a date that comes by very soon, I think, where it will no longer be possible for anyone to register and run against them. Okay, so in other words, Fannie will not have, she's currently running unopposed. I think she'll continue to run unopposed unless someone drops in like any minute. Same thing with the judge. So I think there's some deadlines coming up about, election deadlines. And if they can postpone a decision on this,
you left at a good
in other words,
time.
Judge
That
McAfee
the state's
can come
argument was
out
horrible,
afterwards,
horribly
and say
boring.
that Fannie
with
should be
PowerPoint.
disqualified. He may not have to face the political consequences of that because the deadline for him to have a competitor may have already passed, right? And I don't know exactly the dates, but the logic remains. Same thing with Fannie. If the decision comes out after, she won't have a challenger and she'll likely be reelected. So a lot of political pressure out there, a lot of legal pressure in there. And I think the judge was very fair today. I think that he asked the appropriate questions of both sides. And quite frankly, I think he's doing everything that he can not to reopen evidence. I think there's a strong inclination by the judge to say, I have enough evidence here. We do not need to keep exposing all of this because it's just causing disrepute on the court and in Fulton County. In other words, it's too messy. It's too bloody, right? Stop the bloodshed. Okay. They're already dead already. Let's just leave it there. Because if they bring back, and by the way, while we're here, I just saw this from Phil Holloway. Okay. So Phil Holloway, there's more to come. We're not done yet. The lawyers are going to be submitting a bunch of other stuff.
No.
And Phil Holloway, the same guy who broke the text message records,
He's talking about
just posted this. He says, big
final decision on the
big
case.
Fannie Willis news inbound.
If the case continues, if it's not thrown out.
On X. He says today, bad news for Fannie. A witness has come forward who saw Nathan Wade at lunch with Terrence Bradley 5 weeks ago. There's going to be audio of a voicemail to this effect soon. The evidence didn't make it into today's hearing, but the parties can file additional motions, as we heard, and Megyn Kelly has the audio. Shout out to Megyn Kelly, who's been breaking some amazing stories on this. Let's see what she
decision on this
says. Exclusive. A waiter. Oh, so they have another affidavit. They can combat Wine Guy with this one.
I think they
reveals he saw Nathan
They
Wade
don't
with
they
Terrence
don't throw the
Bradley
case out,
6
but they
weeks
do
ago at a
remove her.
restaurant.
They're probably going to
Here's
have
the
to move the
voicemail.
case to
Megyn
another county.
Kelly broke it. Here, let me unmute this. Actually, let me switch this. Let me give me 1 second. Otherwise, we're not all going to be able to hear this unless I put it appropriately in this browser. So let's do that right now. Boom. Let's see what Megyn Kelly has for us. New voicemail audio from the Megyn Kelly show.
Listening to the testimony, including Terrence Bradley saying he hadn't spoken to Nathan Wade in 2 years. Well, this waiter drops the following voicemail to Ashley Merchant. Listen.
I'm calling. So I just watched the Terrence Bradley hearing, and I noticed on there he said that he hasn't talked to Nathan Wade in 2 years. But I work at a restaurant here on the square, and I waited on Terrence, BC Chopper, and Nathan Wade about 5 weeks ago.
Wow.
We've reached out to this
Oh my gosh. These dudes are just flat out liars.
person, and he has told us after Nathan Wade joined Terrence Bradley and his lawyer, Chopra, who's mentioned there, at the table, that the waiter introduced himself to Nathan because Nathan Wade was the only one he did not know on a first name basis. Watching the hearing, he was surprised to hear that they, quote, have not spoken in years.
Wow. Wow. Shout out to Megan Kelly and to Phil Holloway and to Ashley Merchant and to that waiter. Shout out to that waiter for giving them a call. Yeah. So they're liars, man. They just got up there and they just lied. Incredible. And man, hopefully the judge does the right thing. And so that's going to get dropped in there, submitted in, and it's just going to be wild to see. So I think it went about as well, about as what we suspected. And they submitted the wine affidavit and all the things. And so, my friends, now it is time to hear from you. What a wild day. And we're going to be here, obviously, when the opinion drops. And so thank you for subscribing wherever it is you're watching this. We also do members only streams. So if you want to do a little extra debriefing on some of this, we're going to be doing that tomorrow morning. We have member only streams on YouTube and on Locals, watchingthewatchers.locals.com. We do shows on Saturday morning, and we're going to.
Thanks for the likes, guys. I appreciate it.
So come and join us, watchingthewatchers.locals.com, or become a member on the YouTubes. Also, if you want to sign up for our show newsletter and access any of the other show segments that we do, robertgovea.com is where you can find all of our PDFs, our newsletter.
Generally, he's usually live at 5 p.m. Eastern time every day with
stuff cooking at
this kind of stuff. So I don't even know if he's going to do that.
We don't have any events scheduled for the next week, but I'm working on it. And so make sure you check out watcherlodge.com. We just had a great politicals and wellness conversation that we're editing right now, and we're going to get it reposted over there. And check it out. But my friends, now it's time to hear from you. I know it's been a long hearing. We got some amazing super chats in the house, including one from Stephen M., which is the biggest one we've ever had here on the channel. Incredible. Thank you, Stephen. And so we're going to go through them and see what you have to say about this. And of course, I'm very grateful that you were here and joining us. I think this is one of the most wild cases that we're probably likely going to see in criminal law. And it's going to be historic because there's going to be consequences that impact the 2024 election. So very, very grateful to have you here. We go live every day of the week at 3 p.m. my time, 5 p.m. Eastern time. And we would love to have you join us when we go live. Of course, we'll be back here with the live regular show on Monday. And so let's hit some of these super chats, my friends. You guys are super generous. Oh my goodness. We got, starting out this morning, we had a beautiful morning. Robert W., our newest supporter. Welcome aboard, Robert. We got Billy N. Says, you know, today is a great day for Fanny to have to take some accountability. You're right about that, Billy. She just showed up there for like, what, 5 minutes and sat in the back courtroom there. She passed one note to her guy to make sure that he, didn't do a bad job. Otherwise, he was going to get indicted too. Thanks for the nice dono, Billy. Thanks for being here. We got Jose G. What's up, Jose? Is our newest supporter. Great to have you aboard. Knox Bierman's a defense attorney in Texas, says, I have to head to my own courts. Can't wait to catch up when I return. Enjoy, my fellow watchers. Enjoy. We did. It was a good one. Milo Phone Bill shared this GIF. Oh, yeah. So this one, he says, we're going to have to see what happens to the RICO expert today. And apparently he flies off the toilet. So I'll let that one play elsewhere. But thank you for that one. That came in from Milo Phone Bill. Glocky says, it's Friday, people. And it's Breakfast Club in the house. And it's good to see you. Glocky says, the lawfare against Trump is temporary, but the glory of Rome is forever. Says, Rob, if you have a minute, read the comment I left about the New York AG. She's unhinged. We'll get to that another time. Glocky says, hey, I think that hacker group was supposed to start dropping court stuff today because I don't think Fulton County paid the ransom. Oh, that's interesting. Yeah, Fulton County ransom. The Fulton County computers been hacked, apparently. And that was interesting. Thank you for that, Glocky. Hey, Drew M is our newest supporter on the tubes, and John B has been a member for 2 months. Thank you, John. Says Big Fanny going down today. I think she's in a bad spot for sure. Jeffrey A says, Rob, can the judge tell Fanny and Wade in advance that he is going to dismiss them and give them a chance to resign? I don't think, not in an above board manner, like that would be a backroom deal type of a thing. Otherwise, that's ex parte communications and not appropriate. But, it's politics. Somebody might give him a heads up. We got Peter. What's up, Peter? Our newest supporter on the YouTubes. Great to have you. We got Tom F says, Fanny's condo was drafty, so Nathan came over to help her seal up her residence. Sometimes when you have like a window that has like a little bit of a crack in there, wind comes through it. And so Fanny's condo was drafty. And so what happened is Nathan needed to come over there and give her some caulk. Put the L in there. Caulking, right? Put it in there. We got Glenn Croy says, hey, what's up, Glenn? Is bringing in 20 membos.
Wow, 32 likes,
Kevin
guys.
H.
Thank you so much.
The Sentinels here. Robert G. We got Chris N. Karen E.
Why
Kurt
is this
B.
connected through the
Edward
Wi-Fi?
H. God Rides a Harley is joining us. That's probably true. I'm a ruler of the planet
Why is this saying
Omicron.
that it's
First A
connected
H
through
is
the
now
Wi-Fi?
joining us. JF is here. Steve O. We got No Chillin'. Diane B. Peter R. Douglas D. Ray H. Will I. Sarah L. And Just D. All joining us. And thank you to Glenn Croy for bringing in 20 new members. We'll see you in the morning stream tomorrow. Debbie G says, will Trump be able to sue anyone, including Big Fanny or Little Nathan, for malicious persecution? That's a good question. It's another tall order. So in other words, once this case was dismissed, does Trump have any recourse? And the answer may be no, right? Prosecutors have a lot of qualified immunity. So is he going to get any compensation on the back end of that? I probably would doubt it, but maybe. We'll see what the judge says. We got Shree. What's up, Shree? Bringing in 5 new members. Michael S., Kim A., the Lost 10mm Socket. You always lose that one. Tambalina and Janie Laney in the house, courtesy of Shree. Thank you, Shree, for bringing the members in. Tammy Beck. Very nice dono. Thank you, Tammy. Very generous of you. No question on that, but very grateful for you sending that in. Lady Ice says, hey, good morning again, Rob. Have you considered trying to read some of the dono chats in the hearing in the moment? It would be fun. It would. But it sometimes is. I try to squeeze it in. I try to squeeze in little blurbs in the middle of stuff. So sometimes it might be too much. We got Penny W says, Rob, thanks for your dedication. I'm learning so much about the law via your content. You are also sharpening my critical thinking skills, improving all areas of my life. Penny, what a nice compliment. And it goes both ways, right? Iron sharpens iron. And we're all here having a conversation about this. And I'm learning a lot too. And I'm really, growing, I think, as a person. And I'm really grateful that you're having a similar experience. And we're going to keep this up for a long time. So thanks for being here, Penny. And Penny's over on Rumble. She's got a Rumble channel. So if you're watching on Rumble or you want to go check out Nurse Penny, go check out her Rumble account, Penny Whitbrot on the Rumbles. Thank you, Penny. Lady Ice, we got Michael R. says, do you think Nathan is billing the state for his time in these hearings? It's a great question. He's probably not, but it would be amazing if they showed up. He's like, well, 2,000 hours, $2,000. It was a full day of me sitting there, $2,000 painting. Hey, JKMT with a nice dono. Thank you, JKMT, for sending that one in. David D says, Rob, can the 8 criminal referrals Devin Nunes sent to the DOJ be revisited if Trump is elected? Crossfire hurricane? Probably. I'd be asking about statute of limitations and stuff like that, but probably. 2019, if he's back there 2025, I think he's probably within the statute of limitations. Liberty or Death says, I thought after Fanny said that she didn't categorize it as a relationship until later, that the lawyer should have followed up with, well, what do you consider a relationship? Okay, when did you first have sex with Mr. Wade? Wouldn't that be victim shaming? They would say that, but it's a good question. Like, if they can't pin down their definitions, well, then you have to help them pin them down because they don't know what gift means. They don't know what marriage means. They don't know what relationship means. It's all strange. So you have to help them define terms. Penny, what's up? Says Nurse Penny here. I too have a brother with an intellectual disability. When you took my brother Joey's call during your show, it touched my heart. He and my bro share the same interest. Here's a gift for your bro. Well, thank you, Penny. We do love Joey here. So, of course, my brother Joey has Down syndrome, and he called in back during the evidentiary hearing. He's very interested in movies, Marvel Comics. He has some videos on YouTube at I Am Joey G. If you look that up, I Am Joey G. You can meet my brother Joey. He's amazing. And Penny, shout out to your brother. You know, they're the best. They're the best. So we're in good company together. And shout out to Nurse Penny and your bro. Thank you for sharing that too. Quarter Native says, awful convenient. There's suddenly someone to say Fanny paid in cash. I saw it. Anyone who believes that is deliberately blind. Wild Things Forever says, okay, I got my popcorn ready. Let's get this party started. It was a good one. Quarter says, next question is, does Brody know the Pelosi's? I bet he does. Yeah, the wine guy, right? He's like the wine guy. GOP Congress says, subpoena wine guy's phone records to see if he got contacted by the Dems and the deep state. In particular, look for Pelosi, Paul, Nancy, Gavin, and all those other connections there in California. Jay Water says, a $400 confession of Hibbing with no gift shop treasures, no photos, no I'm here with stupid shirts next to Pelosi's. Yeah. Did they take any photos and post them on their Instagrams? I don't know. Jennifer V says she doesn't even like wine. Yeah, she's back there right now, hammering the Grey Goose. Her and Nathan are like, oh gosh, we made it. Oh, slamming them back. Stephen M says Anna Cross removed herself. At least one of them had ethics. Thank you, Stephen. And I know there's a really nice one coming in from you, so thanks in advance. Barb's Loves Alaska says businesses keep register receipts so there can be some digging at the wine business for their records on that date. So to determine if cash was in fact paid by Fanny. Good to see you, Barb's. And thanks for watching over on Rumble and being a member over there. We got Frank L says, let's get her done, counselor. Are you going to cover the Letitia James money bots? We already did. Yeah, Frank, we already did that. I think this week we had a full segment on that and read through that amazing X thread by Mel. It was great. The segment should be up on that. Joel R says, you know what makes me mad? Fannie and Wade get free legal defense for this case. They do. It's the entire Fulton County Prosecutor's Office is now on Nathan Wade's side. Crazy. Fannies do. NY says, how much does the fact that she paid cash one time help her? How does it get around the Georgia ethics rules that was not $1 could come from Wade to Fannie since he's a contractor? Even if they paid 50-50, it doesn't absolve them of this problem. Totally. She lied. He lied. Clearly. We got Surfer Rick says on Cross, Nathan said that he couldn't recall if he traveled with Fannie in 2021. I bet that's in the defense close. I don't know that we heard that specifically today. Yeah, and that's curious, right? I can't recall. Why would he be traveling with her at all if you're not in a relationship? Glenn Croy bringing in 10 new membos. Thank you, Glenn. NH is coming in. Zach J, Lawrence K. We got Christy L. Wire Rat is here. POV Walks with Roving Cyclops. Well, we got Paul. That sounds pretty cool. Point of View Walks with Roving Cyclops. Paul J, Renee C, and John M all coming in courtesy of Glenn Croy. We got this one from Felix. I believe they had hit Brad with the assault that made him clam up, but all this really makes the DA look like a bunch of cut rate attorneys. They look terrible at their jobs. And I think they are, honestly. It's like, wow, even worse than I thought. Quarter says, Rob said, all rise. And 3 of my dogs looked at the TV and they stood up. Hey, shout out to those real good boys over there. Real good boys. It's true. We all have to rise, even to pay our respects. Even our furry friends have to, pay their respects to the judge. It's the judge. Ike's girl says, Anna mad after seeing them pay invoices. Oh yeah. So she's like, wait a minute. You were getting 700 grand. I got 130. This is racist. Real with Robo's in the house. What's up? Says Anna is gone because she proved Bradley and his rise is a liar. And that means all are liars. By the way, CNN cuts off the part on their stream. Expect guests. I invite them all. Real with Robo. Thank you for that one. Is Good Logic in the house? I think I saw Good Logic's in the house. Shout out to our friend Good Logic. What's up, Joe? My friends, if you're not familiar with Good Logic, he's right next door on YouTube. He's right next door on Rumble, and he's right next door on Locals. Of course, he does great work. And we love Joe. Shout out to Joe and Good Logic. Make sure you're subscribed to his channel. And he's covering this stuff too. So alternative takes and more analysis from our friend Joe. We got Ike's girl. What's up? We got This one from Gordon. Gordon B says, I am exercising selective speculation soon. You can get away with it. I guess if you're charged with a crime, like in Fulton County, just say you don't remember anything. And I think you're off scot-free. Dapper Dave says, Dershowitz believes the judge is going to split the baby. Wade gets disqualified and Fanny stays because he's looking for his own political interests. I don't know how he does that. I think it starts with Fanny. I think they all got to go. We got Helen F. What's up? Shouting out from Sweden. Shout out to our friends in Sweden, man. That's super cool. I'd love to visit your country one day. It's going to happen. Eddie Block Film says they are bluffing because they don't want the evidence in. I think that's been true. A lot of evidence is coming in. So, and I think now their bluffs are being called out. They're being called liars about that. That was a big mistake. Felix is here. Says, winery affidavit looks like a note passed in a high school classroom trying to tell a girlfriend that all that they did with each other was taste milkshakes. And he didn't even pay for it, so it wasn't a real date from Felix. Yeah, it was pathetic. It's like, this is what you got. This is going to exonerate your DA, some random dude at a winery who said Fanny paid with cash. Thanks. That's your big saving grace? Wow. Barb's Loves Alaska says, someone mentioned on a stream earlier that the judge and Fanny's position are voted on in May. To date, no one is challenging the judge's seat and no one is challenging Fanny's position as a factor. Okay, so I was looking at these dates earlier. We were looking at these on our member-only stream this morning. We were trying to pin that down. Like, I don't know what the timeline is, but I was wondering, because I think there's a March deadline. Like, I think there's a March deadline to submit your applications for positions that may be voted on in May. It's something like that. So if they waited, like if the judge waits until after, like let's say he disqualifies Fanny and dismisses the case. Maybe there's a bunch of people in Fulton County who say, I'm going to go get this judge, get rid of this judge. Well, what if it's too late to run against him by the time he releases the decision? Does that insulate him so that he'll be back on the ballot because he won't have a challenger? Got to consider those things, but I don't know the specific timeline. It's just an interesting thought. Rob is here. Says, wouldn't running for office for the purpose of prosecuting Trump be a personal interest conflict of interest? Yes, I would certainly think so. Yeah, and that's like Letitia James to the T. Felix says, not only that, but the stupid public speech done in church was displaying her racial bias. Yeah, but she says it wasn't about the, it wasn't about them. It was about Marjorie Taylor Greene, I'm sure. John McGarvey says, hey, Rob, I really like this new McCarthy. Talking about Kev? I haven't seen much of the new Kev. Is he on a thing? Is he doing something out there? David D says, you know, I have satellite, which is Wi-Fi dish. My feed is constantly buffering, but only when it's a red-pilled vlogger like you, Rob. I've heard that before. Yeah, I've heard that. And, you know, weird things happen on the tubes. It's probably the feds, you know. The feds in the tubes. Thank you, David. Felix is joining us. Says, I hate when liberals use that kind of example. Cash in the thousands of dollars is not equal to a stick of gum. The fact is that they lied. And why would you need to lie if you did nothing wrong? They clearly lied. Great comment from Felix. Thank you. I agree. I agree. We'll see if the judge agrees as well. Just Cause is here. Modding down the fort for us says, take notes, Nathan. This is how you treat your wife. Talking about Mr. Merchant defending the honor of Ashley Merchant, something that Nathan Wade would never do. Felix says, where are the invoices? Where is the initial contract? For everything. Yeah, for everything. Good question. There were some invoices from Nathan Wade's bills, like we have those, but receipts and cash transactions and deposits and all the things, nope, don't exist. Anukai, what's up? Anukai. Anunnaki. Anunnaki descendant. What's up? Anunnaki descendant. Do I have a book about that? Let me hold on a second here. Do I have this book? Yes. Okay, I know what that is. All right, I know what that is. Anunnaki descendant says, thank you for your coverage and translation of the legal mumbo jumbo. Yeah, there's a wild book out there that talks about the Anunnakis. Yeah, wild. Okay, that's a rabbit hole if you ever want to go down one. Thank you for that one, Anunnaki. We got Roy MC says, I wonder if Cross being missing and not being mentioned here is because she's flipped sides. I don't know about that. She's probably just disgusted and, not partaking. We got Yisraela in the house. Thank you for the pronunciation. I know I'm bad about it. Finally made it to the stream, and I'm Snowbird in Arizona. Love it. Amazing. Well, we're glad to have you here. We love our snowbirds in Arizona, because they come here all the time and generally clog the traffic, but we still love our snowbirds. And we definitely love you, Yisraela. We're glad you made it too. And my other question would be, where are you from? Like, where are you going back to when the snow's over? Grateful to have you here, Yisraela. And thanks for being a member over on the locals. Felix says, her spirit in church where the church members should have rebuked her, since they're hexed by that, and they did not. Repent. From Felix. We got Ole Halnas. Ole Halnas says, hi from Sweden. Man, that's super cool. Again, I can't wait to go visit Sweden. Hi back at you, Ollie. Thank you for being here. We got Felix says, Proverbs 5:3-14 talks about the ways of the adulterous woman. This is the scripture her church members.
Aaron Queen is streaming right now, but it's a horrible
Yeah,
stream. It's cutting in and out constantly.
No weapon formed against me shall prosper. Yeah, okay. All right, Fanny. Okay. Crash is here. Says, Saydow is an old pro. No nonsense. No extraneous gun flapping. Straight to the point. Nice and methodical. I love it. Wild Thing says, it's so sad, but the judge is setting up a way to not find Willis accountable. He's arguing her innocence. And he was poking holes, which I think he was, that was at the beginning. I think he was kind of doing that against both sides. I hope we're wrong about that. I hope that he does do it. Liberty says, what is good for the gray goose is good for the gander. From Steve Saydow. Great comment. Ryan PD says, shouldn't he be pushing the fact that Fanny and Wade should be the new poster children of the film Giglio? We got this one. Felix says, every officer of the court needs to tell the truth under oath. 100%. How does the legal system function if everybody's lying in courts? It doesn't at all. Banks brother, what's up, says, first super, says, I can't wait to hear the state talk about how the defense is being racist. They did, basically. Yeah, racist attacks. Such a persuasive argument. You also saw first female elected DA. So when the judge disqualifies her, they're going to say a white judge and Trump MAGA got the first black female from Fulton County disqualified. Johnny Fives in the house says, all the other cases do matter, but this case is all the court here should deal with. You're right about that, Johnny. Wild Thing says, I can tell you now, based on his questions to the lawyers, he's already decided Wade and Fanny walk, right? In the beginning, you may have felt that way, but hopefully you feel like maybe he was also asking the other side some questions as well. I thought it was pretty fair, all said and done. At the outset, it did feel like he's a little, poking holes, but we were waiting for him to poke holes at Adam, which he did. America First in the house says, hey, how's it going? It's going pretty good, America. Had a lovely Friday. Hopefully you did too. Voice of the People says, though the chat doesn't, it's going pretty good, America. Had a lovely Friday. Hopefully you did too. Voice of the People says, though the chat doesn't like this judge, to me it sounds like he's trying to cover all angles, so there's no wiggle room in his ruling. Exactly right. So basically the judge is saying, look, I'm going to write this thing down, and I'm afraid that I'm going to be attacked about this. So how do you answer that? Right? Like if I'm the judge, that's what I'm doing. I'm saying, okay, I think this is my argument, but let me poke holes in my own argument, and then let me ask the side to fix those for me. And then if those are good, then I know my argument is solid, and then I can release that. So I think that's ultimately what he was doing. Trevelyn Gale. Trevelyn in the house. Thank you, Trevelyn, for sending that one in. And hopefully I pronounced that right. Hey, Jaster M says, I know it's early in the hearing, but I feel this judge doesn't want to be the one to disrupt a huge court case of national interest due to liberal backlash or some other similar reason. It's my interpretation. It's a great interpretation, honestly. It's a public policy, again, court of public opinion, court of law. Court of law, we all see what's going on here, but we don't know what the governor's doing. We don't know what the White House is doing. We don't know what's going on in these other domains that might lead to pressure. And if we came out and we got everything's fine, I wouldn't even be that surprised. I'd be like, I would be disgusted, and I'd say, well, it's pretty much the end of justice in America, because that means prosecutors can do whatever they want all the time and no one cares. But that's why I don't think he's going to do that, because he's got his own rep. He's a young guy. He's like in his 30s. He's got a whole career ahead of him as a judge. But I do get concerned about the politics, because you don't hear DAs get disqualified, especially on a case of national importance like this one. Ike's Girl says, this case has opened Pandora's box, literally bringing in all county offices and their conduct. County auditor, director, comptroller, PR, AP, bookkeeping, they all have the power to stop any spending. I would imagine that, right? I think there's going to be a domino effect. Whatever the judge decides, it's going to cause a lot of ripples throughout the entire government in Georgia. Jeffrey N says, is Nathan billing for this time in court? Wouldn't surprise me. Doug M, Lake and Riley funeral today is why we fight evil. Rest in peace to Lake and Riley. Prayers to her family. We hope that they have a beautiful and honored service today, and I'm sure they did. We got Marine for Life says, Wade is texting Fanny, watch him. He's like, hey, baby, you seeing this BS? Can you believe this guy? He's clearly texting someone. Marine for Life says, Wade is texting Fanny. And we got that one. Voice says, forgot about that. Wade lied in his interrogatories. His wife will get everything that she wants now. That's true. And I think that was already happening. But yeah, and I think that's why the divorce basically got resolved. It's because he's like, do anything, I'll do anything you want. Felix says, I can't wait to hear what the DA's office has to say. PowerPoint slides, wasn't that good. Stephen M says, Your Honor, if you put up with Wade's level of candor, we can't trust you. Yeah, it's just, to even believe those guys were being truthful, especially Bradley, what is your definition of truthful then? Pinochet says, how does this get investigated? The White House and via the executive branch, the DOJ in itself has its fingers in this. There is no way that they didn't know. Well, I would imagine that they probably did. I think the whole thing is tainted from the outset, right? Fanny got the call from the White House to do this. What's up, Trevelin? Trevelin Gale says Wade and Willis was living on the back of the Trump witch hunt gravy train. Trevelin in the house. They were, yeah. And if they didn't indict Trump and the 19 co-defendants, they would have no money for their vacays. Frank L says, a lot of bored lawyers at those conferences, huh? Yeah, those conferences, man, those attorney conferences, especially the ones in Vegas. Everybody, all the lawyers, they're like, we're going to go learn about improving our law practices. We're going to learn about the latest technology. Yeah, right. Yeah, break. All right. We got Todd Scott. What's up? 22K people in here, man. It was great. We had a great stream, and I'm just humbled. And it's awesome that we all get to talk about this together. It's really, really cool. Thank you, Todd, for saying that. Y'all hit that like button yet? Good reminder. Thank you, Todd. Felix says, 84-1, I wonder if we're going to have an Untouchables like in a 1987 movie, you were on the list moment with this judge, meaning Fanny and Wade have something on the judge too. I certainly hope not. Hopefully he does the right thing. Jennifer says, I've had to do many silent screams to deal with the anger I feel at the deep corruption and the filthy criminal acts by Swampy Willis and Wade and Bradley. The judge must disqualify these people, or I'm going to be angry about it. Jennifer, hang in there. We're going to wait for justice to prevail. Hopefully it does. And we'll be better off for it, all of us, even the people of Fulton County. It's not good for them to have corrupt prosecutors. Marine for Life says, I know Fanny is watching in her office. You think when the state goes to give their closing, Fanny comes bursting into the courtroom like the Kool-Aid guy, just like she did when she testified? Oh, yeah. Let's go. Remember that? Ray K. WTF, where are the funds, Nathan? Where'd those funds come from? Richard T says, congrats to Lauren De Laguna for passing the bar in Arizona. She's also single, winky face. For all you single gentlemen out there, Richard Townsend, Lauren De Laguna, Arizona bar exam. Congratulations, Lauren. That is a tough test to take. You accomplished it, and we're looking forward to having you as a good member of the Arizona.
Is that the one that Bao
fighting
shared
for
with?
justice out there, all across the fruited plains of Arizona. Good to see you, Richard, and shout out to Lauren. Sounds like a babe. We got Matt P. What's up, Matt P? in the house with a nice dono and the first dono on a live stream. Thank you for that, Matt. Glocky says the saddest thing about watching these older defense attorneys is the fact that once they are gone, the only lawyers America has left is the Marxist DEI trained attorneys who don't even believe in the Constitution. Yeah, or care about ethics at all. They just do whatever they want with their money and just, go to Belize. Mother's love. What about Tish James? It seems that she falls into this conflict of interest category based on her campaign videos. Would it? Angeron says no. New York seems to be perfectly happy with this, but yeah, she's civil. She prosecuted Trump civilly, and it wasn't a criminal case. But yeah, I mean, she's conflicted as heck too. Rex M, man, what a generous dono, Rex. Rex Magnum, thank you, Rex. Says thank you for all your hard work. Great channel, very, very generous of you, Rex, and we're really grateful to have you here. Appreciate the dono and your contribution. That's a big one. Thank you for that. Rex Magnum in the house. Thank you, Rex.
The one that hung out with Chili all the time.
Whoa, it's the newest bar passer. What's up, Lauren De Laguna in the house? Arizona's incoming attorney says thanks for the shout out. Good to see you, Lauren. Very, very nice to have you stop by the stream and say hello. Congratulations again. We got Chubby says, I'm really curious how many of these valid points being made by the defense will actually be responded to by the prosecution, or if they'll just cherry pick what they respond to. Yeah, it's a good question. I mean, they're prosecutors. I figured he had slides. They kind of just mosey on through. They read. That's what prosecutors do. They just read and they have scripts. You should see them in trials, just like checking boxes. It's pathetic. Hey, what's up, Felix? Look at the clerks. They are disgusted. I was also watching for facial features and stuff. I would like to get, HDs on all their faces. I think you're probably right. RMR in the house with the Punisher logo. Thank you, RMR, for the nice dono. We got Daniel L, our new supporter. Danielle L joining us. Felix says this state just got burned to ash. The defense went scorched earth. And it was good. And I really like the tag team approach. They just boom, 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 one after the other to bring it all home. Stephen M says, witness the grand slam at the end. And that was probably from Sadow or from that final guy, right? With the 6 points. Boom, 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 boom. That was great. You're right. We got Felix says they put the DA and the special prosecutor and they lied. Just Ranting says that last lawyer was the nail in the coffin. It was good. That last guy was really good. Very methodical, 6 conflicts. Pick any one you want, Judge, and let's call it. Sharecoat says one major issue with guilt is she received a major benefit of being able to pay half of what their joint vacation would cost if she was alone. Yes. Well, and I think a benefit was having her boyfriend there. It's like if he's not there getting money, then she has no one to travel with. She doesn't have a travel buddy. So now she does. Philip B says, will they be able to appear in traffic court afterwards? Maybe in Georgia. Sounds like they kind of like it over there. Like they I don't know. Maybe, she'll go and maybe be the traffic ticket for judge for some other jurisdiction where they think that she was thrown out on a racist, bigoted attack by MAGA. Stephen M says, last guy crushed it. Their behavior in court sinks the whole office. Definitely clear and convincing. Yeah, it's gross behavior. And it should not be tolerated in law. Like there are other defendants who are not Trump, who are innocent people who have to deal with this office. It's sick. Like sons, daughters, brothers, sisters, mothers, fathers, all going through the system in Fulton County, dealing with Fanny's reign. It's gross. Fanny, says Felix, dig that hole deeper. King Ginger says, wearing red like the Fanny that she is. Rob says, I can see it now. This is all a racist attack on me because I am a black woman, which is basically what we got here. We got Caution Time says, I was expecting Sadow to shine, but Cromwell absolutely crushed that. What a perfect way to finish their arguments. Very, very satisfying. Good to see you, Caution. Former says, back when honor meant something, the oath at one time was beyond a reasonable doubt and a moral certainty. That was removed, and we can all see why. Yeah, to make it easier to convict people. BS, did Fanny kiss the cheek of someone that looked like Bradley? The cheek of someone that looked like Bradley from my tiny faraway view? I don't know. Maybe she was whispering or something. I didn't see it, but yeah, she showed up just to make sure she could cattle prod her attorney. Stephen M says, Fanny, judge says, Fanny, you're going to close? Dig no deeper hole in my court or the bailiff will escort you to lockup. I was hoping that she would do those closing arguments. That would have been amazing. Felix says, hyperbole, Fanny, here come the amateurs. We know Fanny wasn't going to do the arguments because she wasn't there listening to the defense close, but maybe she was on the stream or something. We don't know. Hey, what's up, Chris? Thank you for that one. And Stuart M says, Marie Antoinette, right before the guillotine, said, let them eat cake. Didn't work out well for her. Felix says, Fulton County DA, the office has DEI consequences. They're amateurs. It looked like that today. Kristen G. What's up, Kristen G? Thank you for the lovely dono. Great to have you here. And thanks for being here and joining us. 200 Watt Studio says, why didn't Merchant close today? Honestly, it sounded like Mr. Merchant was the kind of the academic. Like some attorneys are better at like reading case law and mulling it over.
All right, guys, this is what we're watching. I'm gonna go and kill the stream.
Kind of like
get ready for dinner. Wife's getting ready to head home.
So like there's writers and there's punchers. And Ashley's much more of a like, I'm gonna
talk to y'all later. I might go live again later tonight. We'll see. That's how I feel. Date night. Peace.
I see her rolling up, Uber black Cadillac, high heel boots and a sexy body full of tats. Baby's bad, oh baby's hella bad. After her there ain't no coming back. Wanna take a run at that. I think she's feeling me, turn it up a few degrees. My imagination of her body gets the best of me. Oh gosh, she's such a tease, bitten lips, bruised knees. I'm addicted to her, need her touching me, cause she got a bad little waist. And we tearing down this place, off the liquor that we chase. Got some egos to the face, baby, I don't need no space. Coming closer for a taste, and I'll show you how I make everything just fade away. Cause she's like sex, drugs, cocaine, body so insane. Jealous of the clothing that she wears up on that tight frame. All game, no shame, baby came here to play. I feel like an addict cause she's sex, drugs, cocaine. Got a fine little body and her mind's kinda naughty. They say that once you taste it, you cannot replace it. She could get you high, all the dopamine inside triggers fast once she's naked. Her body's a creation. They say the devil made her for his entertainment, but even he couldn't learn how to contain it. Her high heels make a damn good statement. There is no replacement, a body by Satan. She got a bad little waist, and we tearing down this place. Off the liquor that we chase, got some egos to the face. Baby, I don't need no space. Coming closer for a taste, and I'll show you how I make everything just fade away. Cause she's like sex, drugs, cocaine, body so insane. Jealous of the clothing that she wears up on a tight frame. All game, no shame, baby came here to play. I feel like an addict cause she's sex, drugs, cocaine.